Next is a Lordship. My Lord, with the consent of the other side, my Lord, I get to mention item number 50, my Lord, 50.
50.
50.
Yes.
My Lord, there is some difficulty and the council is also out of session. After the question, my Lord, need it maybe 50.
Who is out of state?
SK Ghosh informed.
Other side.
Other side.
He has informed the MJ Kadir Unit Council for the petitioner submits that he has been informed by SK Ghosh Unit Council for the respondent regarding his non-availability. After a week,
applied. And my Lord, the Learned Council also requested for on behalf of team item number 3, my Lord, in his case, my Lord. Item number 3, he requested. He has taken the consent, my Lord, item number 3. That SK Ghosh requested.
on a prayer made on behalf of the petitioner, matter is adjourned by a week. But this is the top of the list. Top of the list matter.
The consent is taken, my Lord.
Consent is not material.
He is out of session, this is my Lord.
Consent is not material. You cannot just adjourn it. We'll fix the date on
Tuesday, my
Tuesday. A prayer for adjournment made on behalf.
My Lord, Tuesday may not be.
Wednesday. Wednesday.
Remember that may be fixed, except Tuesday.
Wednesday.
Wednesday.
However, considering that this matter is the year 2013, a short accommodation is done, directing listing of matter on Wednesday, 27 under the column within inverted comma of the
oblige.
May I please, your Lordship? Lordship, I beg to mention item number 49.
40.
49.
Yes.
The transfer petition, Lordship. I was instructed by my client to not to pursue the matter. But I have checked the record. Record is not wrong. Record is come. So can it be on Monday or any date next week?
49 is it? No, it should be there. We'll pass the order. If it's not there, we'll have it on Monday. You don't want to press this application?
No.
M. Bora, Senate Council for the petitioner submit that she has got instruction not to press this according to sense has not pressed. Yes.
Oblige.
May I please? Item number 28, Miller.
28.
I have to file an application for striking out one of the respondents. I've had a word with my client. Miller. Could it be after 2 weeks? Coming down.
Other side consent.
Yes, yes.
On the prayer of Priyas Bonik, matter is adjourned by 2 weeks to enable filing of IA for deletion of certain response. Yes.
May I please, your Lordship? With the consent from the other side, I beg to mention item number 51.
5 1 year.
Yes.
Yeah, the wrong file has come up.
No, wrong file has not come. There is some mistake in number.
Also, senior advocate Mr. Jain Sahiwala would have, he has a flight to catch. He would leave by 1 o'clock. So the matter may come up for admission in November.
6th of November. Look. 6th of November. Look.
A prayer for adjournment is made on behalf of the TN Sahiwala and Senior Council. Also heard as Decca Council for the petition. As agreed to by the parties based on
6th of November.
Lordship, it may come up for admission.
It comes for 3 matters. There's a 6th November. Interim order is
Yes,
today.
yes, that may be fine.
Interim order passed section connected up.
Oblige.
Yes.
May I please, your Lordship? Lordship, I beg to mention for listing a IA. Agency is that, Lordship, we have filed a CRP for dismissing a title suit by the civil judge Kipsagar. But the title suit is dismissed, but the counterclaim part is going on, Lordship. So next date is fixed on 26. So Lordship kindly release them at around 25 Lordship, Monday Lordship. This is the urgency Lordship.
When did you file?
Lordship, we filed last listed on 21/8/2023 Lordship, August.
What were you doing all these days?
Lordship, the
25th is very difficult.
Lordship already notice issued, notice served. So Lordship already in this notice already issued.
Today is,
Lordship.
tomorrow is a non-working day, so it's difficult on Monday.
Lordship,
We'll have it on 27th.
obliged.
May I please, your lordship? I have paid for listing of a MSc appeal lordship for orders. I am for the respondent claimant. The appeal was admitted and award has been stayed. But since 2011 November 2021, it was not listed. So I prefer listing any day
Next Friday.
of life.
May it please your lordship, with the consent of the other side, I'd like to mention item number 6, lordship.
Yeah.
Lordship, kindly adjourn the matter for the day. Conducting counsel, Mr. S.P. Chaudhary is not well, Lord.
It is submitted.
उसमें
Yes,
fix
please.
the date, lordship. Matter में fix date में भी given, lordship. On
You're for whom?
I am for the respondent.
Item number 6.
Yes,
Your name is not there.
yes, I am telling Uncle not clear.
For whom?
For the respondent, full respondent.
Mr. Jain is not there now.
Yes, he's there. He's also.
It's submitted that P.S.P. Chaudhary Learned Counsel for the petitioner is having some difficulty and therefore adjournment is paid for. Sarah, this on Wednesday next
Uh,
or Friday next?
not
Right,
Friday,
right.
then on 4th of October.
What about 29?
So I shall not be available.
Okay. As agreed to by the parties, this on 410.
May it please, your lordship. May it please, your lordship. Lordship, item number 47 of the daily list, lordship.
Hmm.
So senior counsel is not there. He's out of station, lordship. Maybe come up on the next week.
47.
Testamentary of appeal, lordship.
You are for?
I put D. Chaudhary for the
Okay.
petitioner.
Taking the consent of the other side.
Yes, sir. We have the consent.
It is submitted that Sri D. Chaudhary Learned Counsel for the petitioner is having some difficulty. This after a week.
My lord, my lord,
Okay.
I file an arbitration petition very long back, but not listed.
In what? The second appeal.
Second,
We'll have it next Wednesday.
127. 127.
27th.
May I please, your lordship? Lordship, I beg to mention item number 15 for withdrawal, lordship. The matter has been amicably settled between the parties.
Are you on record?
Yes, your lordship.
What is your name?
S.K. Gupta.
Sri S.K. Gupta Learned Counsel for the petitioner submit that the matter has been amicably settled and accordingly he has instructions not to press petition. Sarah? The petition according to dismissed as not pressed.
Obliged.
My lord, item number 44.
Yes.
My lord, this is a very urgent matter. We filed IA on 2nd September. Today it had been listed. My lord, your lordship granted interim injunction. One of the defendants has started construction of building, violating the injunction order passed by your lordship. So in that way, it is urgent.
But if there is a case of violation, we have the remedy under the law.
My lord, we have filed the violation petition.
Violation petition
And
we have
yes.
filed.
It has come today, but problem is that, my lord, item 44. Before your lordship rises,
We cannot assure. There are many methods. But we'll try.
Here, please, your lordship. I beg to mention item number 19.
19.
Yes, lordship. K. Gogoi was supposed to appear in this matter, but due to personal difficulty, he couldn't appear. So kindly
Who-
matter may be
Who was supposed to appear?
K. Gogoi, lordship.
Okay.
So kindly matter may be fixed any other day.
Your Sharma.
Yes, lordship.
MS Sharma, Learned Counsel submit that her senior K. Gogoi is having some difficulty today. So please after a week.
Okay.
We'll have the motion first, then we'll have the top of the list. Okay,
May it please your lordship. My lord, the
caveat,
caveat is there.
I must heard and discuss with council for caveat who has lost this caveat in respect of an order dated 7th, 2020, as per the learned civil judge number 163, Qatar at 13 red to number 30 of 2010. The caveat would be heard, even court proposes to pass an interim order. There are caveats then discharged.
Lord, your petitioner filed an application on 12/1/2023.
Just a minute. Who are you?
Defendant, my lord, petitioner defendant,
Petitioner is the defendant.
my lord.
Suit for
Suit for, my lord, right title and interest and for recovery of the possession.
go for it.
Now, ordinarily, my lord, the documents which is required to be filed, it is along with the written statement in terms of order 8, my lord. Now, in this case, those documents were not annexed, but the averment was made in the written statement. Now, after the evidence is over, my lord, an application is filed on 12/1/2023, which your lordship will find at page 35 and 36. Two applications were filed, one for taking judicial notice and one for calling those documents from the sub-registry office.
35.
Page 35 is for calling for those, taking judicial notice of those two documents. Now, your lordship may skip this. Now, your lordship may come to page 36, that is the vital one. And the learned judge did not give any finding why he has rejected it. Your lordship may read 36, my lord. That this day in the aforesaid suit, the defendant number 1 filed the certified copy of some document described in schedule below. The submitted documents are imported one. The original documents of state certified copies are not traceable. To prove the case of the defense, the documents described in schedule below are necessary to be proved. In the circumstances, the relevant book volume of the documents described in schedule below are necessary to be called for from the senior sub-register Silchar for any person subordinate to him on his behalf to appear with book volume of the document described in schedule below as official witness, otherwise it will suffer irreparable loss. It is therefore appropriate that the above circumstances the court will be pleased to allow the petitioner be called for the relevant book volume of the document described in schedule below. Now, schedule your lordship will find in the next page, at page 37. Certified copy of deed of gift executed by Umarani Banik and others in favor of Silchar Municipal Board on so and so, deed number so and so. Certified copy of sale deed executed by Umarani Banik and others in favor of Silchar Municipal Board on 5/5/2010, deed number so and so, from the office of sub-register of Silchar. Now, the objection was filed by the other side, which your lordship will find at page 38. The objection is that it has not been endeavored to get the documents in appropriate time. That was the objection which your lordship will find at page 38, paragraph 4. At the appropriate stage, the defendant number 1 did not take the requisite step to call for the document
and at the penultimate stage in the suit, that is at the stage of argument, and hence the petition and objection is liable to be rejected. After the closure of the cross-examination of DW1, the defendant number 1 is trying to cover up the lacuna which is impermissible. Now, how the order was passed, your lordship will find at page 40.
40.
40. Both the sides are represented. Today is fixed for order on petition number 237, filed by the defendant number 1, praying for taking a judicial notice to the certified copies of the gift deed executed by the Umarani Banik and others in favor of Silchar Municipal Board, dated so and so. Then, my lord, your lordship may skip this. Then the next page at page 41, other side file objection contending inter alia that there is no cause, reason or justification for filing the petition, that the petition is not maintainable. Now that in terms of section 59 of the Evidence Act, which are the items judicial notice can be taken, that has been given a list. Your lordship may skip that. Now that page 43, the section further prescribes that the judge is also expected to have knowledge regarding matters of public history, literature, science, or art. The judge may refer to books and documents. If a person asks the court to take judicial notice of any act, the court can refuse to do so unless and until such person produces any such book or a document regarding that fact. The judicial notice allows a well-known or authoritatively attested fact to be produced as evidence without having to prove them, as they cannot reasonably be doubted. Now, your lordship may skip all these things now. The last but one para, hence from there. The pair of the defendant praying to take judicial notice of the gift deed number so and so, sale deed number so and so is rejected. Now, the last part, consequent thereupon, petition number 246, filed by say defendant number 1, paying for calling for the book volume of gift deed and sale deed from the office of sub-registrar is also rejected. Now, why the documents are rejected? Well, there is no finding. He did not say, because the earlier petition that is taking judicial notice, that was rejected. Because of that, this is also rejected. Now, my lord, I will take your lordship to section 30 of Civil Procedure Code.
Three zero.
30, my lord. Has your lordship got it? Power to order discovery and the like, subject to such conditions and limitation as may be prescribed. The court may at any time, either of its own motion or on the application of any party, make such orders as may be necessary or reasonable in all matters relating to the delivery and answering of interrogatories, the admission of documents and facts, and the discovery, inspection, production, impounding, return of documents, so and so, so and so. Issue summons to persons whose attendance is required. Now, my lord, this is the position of law. My lord, if the court finds it is necessary, it is duty of the court to call for the record, document at any stage. My lord, to that effect, my lord, your lordship may also see Order 8. Order 8, Rule 1A, Sub Rule 3. Your lordship may look at 1A.
Order 8, Rule 1.
Rule 1A, my lord, capital A. Duty of defendant to produce documents upon which relief is claimed or relied upon him, where the defendant bases his defense upon a document or relies upon any document in his possession or power in support of his defense or claim for set-off or counterclaim, he shall enter such documents in a list and shall produce it in court when the written statement is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the written statement. This is, my lord, ordinarily one has to do it. Now, your lordship may see subclause 3.
Yes.
A document which ought to be produced in court by the defendant under this rule, but is not so produced, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. Now, my lord, if we file an application to take leave of the court to call for those documents, my lord, it is the duty of the court to see that whether these documents are at all necessary and whether any person will be prejudiced if these are not called. Now, my lord, to that effect, I'll take your lordship to a direct decision of Honorable Appeals Court. There is a reported,
But did you take recourse to this provision?
beg your pardon.
Did you take recourse to this provision of taking leave?
My lord, yes. Your lordship may see that
Where is that application?
that application has page 36. We have given the reason also why
But did you take leave?
36 days, my lord. That
No, this is another, we have seen this.
no,
That
this
was
is,
what we were wondering. You have not sought leave of the court
my lord,
to produce.
my lord, your lordship is very correct. This is the application filed for, the intent is that, but the,
Will not be hyper-technical. That
My lord.
Since you have not mentioned order
Yes,
8, 183,
Right,
will not,
right.
will constitute as an application for leave, provided it makes out a case that you have actually paid for leave.
my
You have
lord,
not paid for leave.
my lord, these words, you rightly, your lordship has said that.
Not word. You can choose any other expression. Here, what you have said, that the relevant book should be called for. It's not a leave of producing.
My lord,
We have, we do not know what powers you are trying to invoke, but you had paid for having those volumes from the office of the senior sub registrar to be produced.
my lord, actually, my lord, as your lordship understands, the inartistic drafting of the council, the party should not suffer. In all probability,
No, we are not on the, neither on the format nor on the thing. We are only on the content. What was the actual meaning sought to be conveyed to the court? What was the prayer? We'll go by the meaning.
My
We'll
lord,
not assign any other thing. We are absolutely with you that some mistake, some omission of some expression will not go by that.
My-
We'll see the intent, but that was not there.
now to that effect, my lord, these documents has your lordship has seen in the written statement we have indicated, but it is the fault of the council. He ought to have produced along with the written
That is
statement.
why
He did not.
that is why the provision for leave is.
Yes, yes. That's the
not do
reason.
it with the, and this provision is part of the substantial provision.
Yes.
Substantial provision is that you are mandatory is required to file all the documents with copies along with the written statement.
Yes.
A similar perimeter provision in the plain.
Your lordship is very right. Well,
And if you do not do,
ordinarily,
you'll have to seek leave. You have not sought for leave.
ordinarily, my lord, a council who is a competent one, who is a, my
Okay,
lord,
what is this?
in know of the thing.
What
Now,
is
your
the
lordship, 2020, 10 SCC, page 706. I'll take your lordships to para 8 to 11,
2020,
my lord.
10
Page
706,
706,
paragraph.
paragraph 8 to 11. Subrule 3, as quoted above, provides a second opportunity to the defendant to produce the documents which ought to have been produced in the court along with the written statement with the leave of the court. The description conferred upon the court to grant such leave is to be exercised judiciously. While there is no straitjacket formula, this leave can be granted by the court on a good cause being shown by the defendant. It is often said that procedure is the handmaid of justice. Procedure and technical hurdles shall not be allowed to come in the way of the court while doing substantial justice. If the procedural violation does not seriously cause prejudice to the adversary party, courts must lean towards doing substantial justice rather than relying upon procedural and technical violation. We should not forget the fact that litigation is nothing but a journey towards truth, which is the foundation of justice, and the court is required to take appropriate steps to thresh out the underlying truth in every dispute. Therefore, the court should take a lenient view when an application is made for production of the document under Subrule 3. Coming to the present case, the defendant have filed an application assigning cogent reasons for not producing the document along with the written statement. They have stated that these documents were missing and were only traced at later stage. It cannot be disputed that these documents are necessary for arriving at a just decision in the suit. We are of the view that the court below ought to have granted leave to produce these documents. Therefore, for the foregoing reasons, the appeal succeeds. Now, here also, my lord, so far factual aspect is concerned, my lord, it is in the same stage. The lordship has seen these documents are very much required for the substantial adjudication of the case. My lord, what happened in this case, Silchar Municipal Board, they have their building there, this is their land, and they are claiming now it is their land. Now, unless these documents are, my lord, proved in the case, substantial justice cannot be given. Now, my lord, another decision of this honorable court, I'd like to take to your lordship,
Yeah.
that is 2016 Code GLR 298, paragraph 5 and 6. 2016 Code GLR, page 298.
Paragraph.
Paragraph 5. Coming to the, as a lordship got that. Coming to the merit of the MP in order, it appears that learned trial court refused to grant leave only because of the fact that the defendant did not file the same along with written statement or at the stage of filing document, and that the ground mentioned in the application was not satisfactory. The learned court has not considered as to what was the ground taken in the application. The learned court also not considered as to whether the document is
You're reading
necessary.
paragraph
5 minutes.
5.
Well, the last.
Just 5. Yeah.
Coming to the merit of the
Yes.
MP in order, it appears that learned trial court refused to grant leave only because of the fact that the defendant did not file the same along with written statement or at the stage of filing document, and that the ground mentioned in the application was not satisfactory. The learned court has not considered as to what was the ground taken in the application. The learned court has also not considered as to whether the document is necessary for arriving at a just decision in the suit. This is important because under Section 30 of the Code of Civil Procedure Code, courts are vested with power and responsibility to issue necessary order from time to time, inter alia, directing the parties to produce or give evidence in regard to materials which are necessary for arriving at truth. In a catena of decision of Honorable Supreme Court deprecated the actions of the learned courts below for not taking recourse to the provision of Section 30 at the time of admitting documents into record or at the time of trial. After all, the litigation is nothing but a journey towards truth, and a court is required to take appropriate steps to flesh out the underlying truth in a dispute raised between two parties. Observation made by the Honorable Supreme Court in the case of so and so may be referred in this regard. Upon perusal of the written statement, it appears that the document sought to have been brought on record by the defendant was mentioned in paragraph 9 of the written statement. And so even if the document is brought on record, it cannot be said that the defendant has sought to set up a new case or that the document would be beyond pleading. On the other hand, these documents may be relevant for the purpose of deciding the claim of the plaintiff over the suit land. Considering the facts and circumstances, it does not appear
Yes.
that.
Favorite.
Now, this is all about, now the next decision that is also more important, my lord, that is 2012 5 SCC, page 370. That has, my lord, clarified what is the rule of advocate and the rule of the judge. Lord, I will take your lordships to page 32,
2012.
my lord, 2012 5 SCC, page 370. It's by Honorable 3 judges. My lordship may look at paragraph 32 onward,
Paragraph 32.
my lord. In this unfortunate litigation, the court's serious endeavor has to be to find out where in fact the truth lies. The truth should be the guiding star in the entire judicial process. Truth alone has to be foundation of justice. The entire judicial system has been created only to discern and find out the real truth. Judges at all levels have to seriously engage themselves in the journey of discovering the truth. That is their mandate, obligation, and bounden duty.
This case was referred by our
Yes, ma'am.
Maria.
Maria. My lord, then justice system will acquire credibility only when people will be convinced that justice is based on the foundation of the truth. In Mahanlal Swamy versus Pancho, this court observed that in such a situation, a question that arises for consideration is whether the presiding officer of a court should simply sit as a mere umpire at a contest between two parties and declare at the end of the contest who has won and who has lost. Is there not any legal duty of his own, independent of the parties, to take an active role in the proceedings in finding the truth and administering justice? It is a well accepted and settled principle that a court must discharge its statutory function, whether discretionary or obligatory, according to law in dispensing justice, because it is the duty of a court not only to do justice but also to ensure that justice is being done. What people expect is that the court should discharge its obligation to find out where in fact the truth lies. Right from the inception of the judicial system, it has been accepted that discovery, vindication, and establishment of truth are the main purposes underlying the existence of the courts of justice. Then your lordship may see at para 38. Certainly the above is not true of the Indian judicial system. A judge in the Indian system has to be regarded as failing to exercise its jurisdiction and thereby discharging its judicial duty. If in guise of remaining neutral, he opts to remain passive to the proceeding before him, he has to always keep in mind that every trial is a voice of discovery in which truth is the question. In order to bring on record the relevant facts, he has to play an active role, no doubt within the bounds of the statutorily defined procedure record. And some quotation from Lord Denning. It is all very well to paint justice blind, but she does better without a bandage round her eyes. She should be blind indeed to favor or justice, but clear to see which way lies the truth. Then, my lord, paragraph 41. In civil cases, adherence to section 30 CPC would also help in ascertaining the truth. It seems that the provision which ought to be frequently used is really pressed in service by our judicial officers and judges. Then 42, that section has been quoted. Then 43. Satyamave Jayate, literally truth stands invincible, is a mantra from ancient scripture, Manduka Upanishad. Upon independence of India, it was adopted as the national motto of India. It is inscribed in Devanagari script at the base of the national emblem. The meaning of the full mantra is as follows: truth alone triumphs, not falsehood. Through truth, the divine path is spread out by which the sages, whose desires have been completely fulfilled, reach where the supreme treasure of truth resides. Then, my lord, I will skip the other paragraph. Then take your lordship to paragraph 51. It is said both about judges and lawyers. In the administration of justice, judges and lawyers play equal roles. Like judges, lawyers also must ensure that truth triumphs in the administration of justice. Then paragraph 52. Truth is the foundation of justice. It must be the endeavor of all the judicial officers and judges to ascertain truth in every matter, and no stone should be left unturned in achieving this object. Courts must give greater emphasis on the veracity of pleadings and documents in order to ascertain the truth. Now, my lord, then I'll just take your lordship to para 70 in regard to the merit of the case. If anybody says, my lord, I am in possession of the land, then what documents you will have to furnish? In this case, your lordship will find these are all, my lord, not there at all. Para 70, it would be imperative that one who claims possession must give all such details as enumerated herein. My lord, the plaintiff is saying they are in possession, but they could not give all these things. Who is or are the owner or owners of the property, title of the property, who is in possession of the title document, identity of the claimants or claimants to possession, the date of entry into possession, now so on and so forth, my lord. These are the criteria, my lord, one has to give. Now, in this case, of course, there is the trial stage, they can give it now also. Now, my lord, coming back to the case, your lordship has seen, we are not setting up a new case here. In our pleading, we have said that these sale deed and the gift deed, it is required to be proved. Therefore, the sub-registrar may be directed to produce that.
Let us hear it.
Yes. Your Lordship will find it at page 29. My- The statement we have made at paragraph 15 at page 31. That the predecessor in interest of the vendor of the answering defendant
Paragraph?
paragraph 15, 1 5 minutes. No, your Lordship may see from 14 itself, para 14. That the Silchar Municipal Board for a public purpose, that is for establishing a municipal market, was searching for a plot of land in new Silchar area and has purchased a plot of 7 cutters of land, white registered deed number 724 dated 5/5/2010 from Srimati Uma Bonik and others, the heirs of late Shamal Kant Bonik, following a deed of agreement dated so and so. Also, the said heirs of late Shamal Kanti Bonik by registered gift deed dated deed number 1386 dated so and so, donated an adjacent plot of 5 cutters of land to Silchar Municipal Board with the condition that an auditorium is to be constructed on the said land in memory of her late husband, Shamal Kanti Bonik, and handed over the possession of both the plots of land, that is total 12 cutters of land. Now, these the two, my lord, the gift deed and sale deed, my lord, these are required to be produced before the court by sub-registry office in order to prove those documents that this land belongs to the Silchar Municipal Board. And unless these are produced, my lord, I don't think any adjudication can be made to that effect. And no doubt, my lord, there is a fault on the part of the lawyer. And your Lordship has seen how the drafting is. It's alarming if the new generation comes like that. I don't know what will be the position of this profession. And for this sort of lawyer, my lord, the client not supposed to not to suffer.
Yes.
Now, therefore, my lord, I feel, my lord, for the ends of justice, the petitioner should get a second chance so that the substantial justice can be done by the court. And it's nothing new, my lord. It's, they are not going to be prejudiced by it. Only thing, my lord, your Lordship can see one thing. The appeals court time and again and say, if the frivolous cases comes up, how those are to be minimized. There must be some measure to be taken by the court by imposing heavy costs so that one cannot stop all this frivolous litigation at all, but then it can be minimized. Now, these are the, my lord, pronouncement of the appeals court in many of the cases. Now, this is one of the cases I will say is a frivolous case. Ultimately, my lord, when the suit will be decided, this will come into picture, and unless these documents are not called for, my lord, there will be some problem in rendering justice. That's my submission.
No, but you have said that one of the prayers is also for recovery of this,
Yes.
and you have also shown 2012 5/370,
My lord.
paragraph 7,
Right.
which one is required to plead while having a case of possession. Now that the prayer is not for confirmation, it's for recovery.
They are saying recovery of position. Now, in the evidence, they have said it is in their possession. Now, when you say that, then you will have to comply in terms of this para 70 mil. Anyway, these are the things, my lord, to be taken care of by the trial court. At this stage, my lord,
Yes.
possibly we cannot go on all those.
Anything else?
No.
Since you are on caveat, if you wish, we can take this up for final disposal since you have heard, or if you want to make your arguments on it, you can issue notice and have your.
Only
Because
one.
if we hear you substantiate, then we'll not we'll go for a final. Either we allow the petition or
May I make a, may I take a?
since today is the first day, so
Yes.
therefore I am giving you this hope. If you are prepared to argue on merit, since he has made his arguments extensive, and if you think that you will make it on another,
My lord, only, my lord, my submission would be, my lord, I have a preliminary objection to this petition, only two-liner objection, my lord, whether your lordship can take cognizance of any of the amendment made in this petition or not. My lord will kindly come, who is the petitioner in? Who is the petitioner in this case, my lord will kindly. Only, my lord, the preliminary objection
in the
in this CRP. Page number 2, post title.
Yes.
Silchar Municipal Board represented by its chairman.
Yes.
My lord will kindly come to the affidavit. Page number 16. Kumar Gaurav Das, assisting officer.
Hmm.
And in para 1, he says, I am one of the petition. A municipal board cannot be represented by any assisting officer, my lord, in terms of section 37 of the Municipal Act. He can either he will represent by himself or he can delegate it to a vice chairman.
we may not be so technical.
But-
arraying of parties, we don't find it fault. Yes, ideally the person should have come now. The assisting officer has come. He has made a
And
strong
there is no
statement.
authorization also.
He has said that he has been authorized. Where it is.
And he says he is a petitioner. But it is not a
That's wrong. Therefore, that will not. In other cases, yes, we would have accepted. But this case, if there was wrong arraying of parties because somebody else had come, he is an officer of the municipal board. He has been authorized.
the board authorization.
For that, the petition will not pay. You can make a.
My lord, in this case, my lord,
We thought you had a good case on marriage. Where are you
Yes.
coming on this?
no, I'll make my submissions on merit. Now, my lord, what has happened in this case,
We
my
are
lord?
going for a disposal.
My lord, what had happened in this case, my lord?
Just the. You for whom?
I'm for the plaintiff in the original
How many plaintiffs?
one.
His number, respondent number? Only one
Respondent number, sole respondent.
respondent.
I'm for respondent number 1, my lord, because there are other,
That is what.
yes, my lord, because the development authority and other,
But you are the plaintiff.
and the plaintiff.
Plaintiff is one.
Plaintiff.
Yes.
Now, my lord, in this case, my lord, firstly, my lord, the evidence of the defendants were closed on 22/9/2022. My lord will kindly take note of it.
22
9/2022
evidence.
of defendant closed.
From where do you get?
This is the copies, my lord. I'm furnishing, my lord. And one more date, my lord, then I'll work. And on 12/12/2022, an application for adducing additional evidence by the defendant were also rejected. And then on 18/1/2023, they came up with these two petitions, my lord. Now, my lord, there are the impugned judgment speaks about two petitions, my lord. One is the impugned judgment speaks of two petition, my lord. One is petition number 237/01.
Yes.
237/01, that is for taking judicial notice. And the other is petition number 246/2013, which is an application which we can relate it to section 30 of the CPC at best, my lord. Now, my lord, the impugned order assailed in this CRP is a common order by which both this petition, prayer for both this petition was rejected. Why I am making this submission, my lord? So my lord will kindly come to their prayer in the CRP.
Yeah.
Page number 15.
Yeah.
Here they are only assailing the rejection of the petition bearing number 246/2013. Sorry, only 13. This is not in relation to year, my lord. This is some number. 246/13. Specifically, they have mentioned the petition number. So they are not aggrieved or they are not assailing the rejection to take judicial notice of those two documents. My lord. Now, my lord. Yes.
Yes.
Now, my lord, what is the implication of this in my limited understanding is this. A submission was made by the venerated senior counsel, my lord, that while rendering the impugned judgment as at page, impugned judgment is at page number 40, the learned court below has not given any reason for rejecting the prayer for calling the record, but has given reason for rejecting the prayer under section 57 for taking judicial notice. My lord, in my limited understanding, my lord, the learned court below was absolutely correct. My lord, what was their purpose, my lord? Evidence of the defense is closed. 8 dates. I will furnish a copy of the online. Nowadays, we get this online order. 8 dates were fixed for defense evidence, my lord. They don't exhibit these two documents, my lord. They want to dispense with the requirement of proving this document. Therefore, they file these two petitions together, my lord. The learned advocate at the trial stage, they file two petitions purposefully. They want to call for the record, and they want to dispense proving of those documents, and they want the court to take judicial notice. That was the purpose. He was trying, the defendant were trying to do this. They don't want to prove the document. Now, my lord, to put it simply, my lord, once the prayer for judicial notice is rejected, these papers, assuming is called for, will just remain as a bunch of paper. The court cannot take notice of this. Therefore, the court was right. The court first decided section 57 petition. And the court said, since I cannot take judicial notice, why should I waste time, judicial time, my lord, calling this? Because those were not exhibited. Court cannot go into those documents.
Yes.
My lord, what the counsel is humbly submitting is this, my lord. If this petition would have been allowed by the learned court below, it would have opened a Pandora's box. All litigants, now my lord, one important fact, this matter was posted for argument. This was posted for argument. So, all litigants will come at the age of argument, file an application that please bring these documents, will not prove it, you take judicial notice, and my lord will kindly appreciate these are private documents. Both these documents are private documents. Then in every civil trial, my lord, to whatever little I understand, at the argument stage, like a writ proceeding by means of an additional affidavit, some document will be brought and the application will be filed. Please take judicial notice under section 57. It will virtually make the chapter on proof of document that starts from section 61, runs till section 78 redundant. No documents will be proved. Henceforth, everything by virtue of a judicial. Whether that would be permissible under the scheme of law, my lord, as laid down in the Code of Civil Procedure read with the Indian Evidence Act. That would be my humble submission. Coming to Order 8, Rule 1, capital A, my lord. Now, my lord, Order 8, Rule 1, capital A, in my limited understanding is, if a witness wants to bring a document in evidence, now their evidence is closed, that stage is gone. At the time of evidence, some witness entering the dock, if they want to exhibit, then that stage is gone long back in the month of December dated 2022. So the application of, in my limited understanding, Order 8, Rule 1, capital A will not come at the stage of argument by virtue of a judicial notice. That was their entire purpose, my lord, which is why they filed two petitions parallel. Now, that is what, my lord, I fail to understand, my lord, that once they give up their prayer for taking judicial notice, why they are insisting on Section 30, my lord? Because this will remain as a piece of paper before the court below. It will be mere wastage of judicial time, my lord, because the court cannot go into. The only window to go into those documents were Section 57 of the Evidence Act. Therefore, in my limited submission, my lord, the judgment which my venerated senior counsel have referred to, my lord, these judgments are at the stage of evidence or in terms of Order 8, Rule 1A, and as your lordship has correctly pointed out, my lord, there was even no leave sought. Additional evidence, prayer was rejected. My lord will kindly take, my lord, though I have not got a copy of this, my lord, but my lord, I am relying on a judgment on 2009 4 SCC 410. My lord, during the course of the day, I'll furnish a copy to the 2009 4 SCC 410. My lord, I'll give a copy, my lord. My lord, para number with name I'll give. I'll just tell what is the ratio laid down in this case, my lord, because it is a motion. Ratio is this, my lord. The Supreme Court says even re-examination is not permissible for filling up lacunas. Even re-examination is not permissible for filling up lacunas, my lord. And here is a case of Section 30 at the stage of argument and to bring in evidence certain documents, my lord, by virtue of a judicial notice. Now, my lord, in my limited understanding, my lord, once they give up their prayer for bringing, give up their prayer under Section 57 for judicial notice, my lord, this prayer is redundant, my lord. And which is why, my lord, the court below, once he has rejected that, he consequently, this also gets rejected. That's my humble submission, my lord.
After hearing him, I don't find anything to be replied.
You have bowed down now.
No. The law is very clear. Your lordship has seen that. My lord, beyond that, it will not go. Because the re-examination.
There can be two implications. That the argument does not even need a reply. There may be two implications. You have accepted everything, or you have think that this does not even call for any reply.
My lord, only thing your lordship kindly see.
Which
What
is
he
the
is arguing,
implication?
he is saying that the fill up the lacuna. Is it we are going to fill up the lacuna? Under certain circumstances, we explain what
No,
are
he
the
has
circumstances.
pointed out some very relevant dates.
My lord, nonetheless, assuming these are all correct, my lord, I accept
We
these are
wanted
correct.
to have your elicit your response on this. Evidence was closed on 22/9/2020, and it was at the stage of argument.
My lord, I
And
accept.
there were 8 days given to you for your evidence.
My lord, all these things may be correct because since he has said from the order sheet, I accept it as it is correct. But I leave up to your lordships only. Even under those circumstances also, a second chance can be given to them. It is just for substantial justice to be rendered. Because now, if these two documents are not brought in the picture, what will happen? My lord, there will be multiplicity of litigation.
But Mr. Doctor, this is the adversarial litigation under the code. We are bound by the code. We are not exercising equity jurisdiction at this stage, that stage.
No, my lord,
What the law prescribes under the code, we are bound, we are confined.
no, my lord, what I am saying, my lord, the learned presiding judge, he ought to have applied his mind. My lord, when he has seen this, that these are the two documents which is highlighted in the written statement. Somehow, my lord, for the fault of the lawyer, in his appropriate time, he did not come. Now, whether client should suffer for that, that is the only issue here. Now, it may be a fact, my lord, for 8 occasions, our lawyer did not do anything. Now, whether we can say that this is the fault of the client. Now, we have seen many of the cases, the advocate goes there, takes time without informing the parties also. Parties are not knowing what is happening in the court. So this is the duty of the lawyer as well as of the presiding judge. Well, he is not a referee of a football match there, that he will give a whistle, somebody will win, somebody will lose. That is, he must show an active role in the process. He is not a passive seated there. He has to exercise his mind that if these two documents come up, what will happen? And if really these documents are not necessary at all, well, it is rejected, very nice. Because the implication of it, of the rejection of it, will have no effect to the adjudication of the matter. But here, these two, this sale deed and the gift deed, these are the crux of this case. They are saying, my lord, Fatima Begum is the owner of the land, who sold this land to this person, the plaintiff. Now, she doesn't have any title to that. And therefore, your lordship will find there's a municipal market going on there, on this land. And they are asking for possession, saying that we are in possession. They haven't shown anything in the evidence. Now, under such circumstances, whether these documents are required to be brought or not, my lord, I leave up to your lord.
My lord, I am not making any submission on the merit of my plaint, my lord, because that's not the, my lord, just one block. Section 68 of the Evidence Act otherwise also bar give deed, because for give deed attesting, it is a document where
We
attestation
are
is
not
supposed.
going to the
The
matter.
trial court will see all these things, my
We
lord.
are not going to the matter. Third, as Dr. Ranjit for the petition. K. Upaman. By K. Third, three, M. Vista. Third, count for the respondent of one. Which one? That consider the subject matter and also the fact that respondent number one, which is contested and the plaintiff in two below, comma. This matter is taken up at motion stage. The petitioner is the defendant in a suit numbered as a suit filed right suit for declaration of right, title, interest, and recovery of possession, which was registered as title suit number 33 of 2010 before learned civil judge number 1, Qatar. Since it is the case of the person that do certain documents were mentioned in the written statement, comma, those were not filed in accordance of along with the state petition and according comma two applications were filed by the petitioner before the learned court. By the first application, comma, a prayer was made to take judicial notice of the state document and state application was numbered as petition. On 237-01. The petitioner had filed another call for the original document, including the relevant book from Office of Senior Sub Registrar, Sister, and that petition was numbered as petition number 24-13. By the impugned order dated 7/6/2023, comma, both the petitions have rejected and the legality and validity of the state order which has been challenged in this petition filed under Article 27 of the Constitution. Dr. Solan Senior Counsel has submitted that the impugned order suffers from material irregularity and illegal as the learned court had failed to exercise power vested in law. By referring to section 30 of the Code of Civil Procedure, comma, it is submitted that under the above provision, comma, adequate powers are vested on court to order discovery comma, inspect, comma, production, etc. And the state power has been ignored by passing the impugned order. The senior counsel further submit that though the second petition may not be structured in the format as required in the format by following Order 8 Rule 1A of the common, the spirit should be followed and leave should have been granted, taking into consideration the nature of documents or documents involved in the petition. He submits that the documents are necessary for a fair and complete adjudication of the lease between the parties. That by drawing the attention of the court to the written statement, common, the senior counsel, by referring to paragraph 14, has submitted that adequate pleading in respect of the document were made, and therefore these documents are not new, and therefore the learned court should have allowed the in the interest of justice. That in support of sub common freedom has placed reliance upon the following issue. So, well, 5 is 370. So, next 2016 Court Keller 98 2010 706. This submission found that the ultimate endeavor of a court is that is is reach the truth, and for such purpose, the views of the court should not be stringent and at times in the interest of justice, lenient views are required to be taken, adopted so far as procedure is concerned, as procedures are handmade of justice. Further submit that this is substantial justice, which is the objective of a judicial system. The learned counsel according to for interference by this court and set by the impugned order dated 7/6/2020 and allowed prayers made in the two petitions. Par contra, we emphasize learned counsel for the respondent number 1, plaintiff, who has entered appearance on the strength of a case, has raised a preliminary objection with regard to maintaining of the present petition by referring to affidavit accompanying petition from submit that the affidavit has been executed by a person not authorized in law, who has also described himself to be the petitioner, and therefore, in that view, the petition itself not coming to the merits of case and opposing contention raised on behalf of petition to discuss the substance that the record would substantiate that the evidence of the defendant were closed on 22/9/2022. He has also submitted that an application of a petition was filed by the defendant, by the present petition as defendant to adduce additional evidence which was rejected on 12/12/2020. He further submits that neither the order dated 22/9/2020 by which the evidence was closed, nor the order dated 12/12/2020 by which the prayer for using additional evidence by the defendant was rejected, were put to further challenge, and therefore the state orders had attained final. He submits that it was only on
18/1/2020
when the present petitions were filed. The business has also pointed out that while the impugned order dated 7/6/2020 concerned two petitions, being petition number 237/01 and petition number 240 of 13, the prayer in the present petition is with respect only one petition, named petition number 240 of the. He accordingly submits that the petitioner, not being aggrieved with the rejection of petition number 237/01, which was in the context of taking judicial notice, the further the present challenge would perhaps not be maintained. He makes a categorical submission that since section 57, since the petition number, since the petition number 237, 237/01 pertaining taking of judicial notice has been rejected by taking court through section 57, by discussing the ingredients of section 57, there is no requirement to cite any reason for rejecting the other as the adjudication of the statement was mere academic. The learned counsel hastily adds that as many as 8 dates were fixed for defendant and on none of those dates any endeavor was made to adduce further evidence. order wins, and presently the matter was posted for argument, and only when the present petitions have been filed. So, he submits that the public intention, that there is an public intention in filing of the present petition, which is meant only to dispense with the requirement of proving the document involved. He submits that the documents being private in nature, comma, a petition for taking judicial notice cannot be filed, cannot be maintainable, it is not maintainable, as that would amount, substitute the rigor of an adverse party, rigor in an adversarial litigation to prove their own document. He has also pointed out that in December 2020, the evidence was closed. In support of the the learned counsel for the respondent has also placed put forth the relevant copies of relevant orders which are made part of that discuss learned counsel in support of the has referred to the
I have the names now.
reported 2009 410, where the Honorable Supreme Court has laid down that even the power of cross examination is to be exercised in a circumscribed manner and should not be allowed to fill up lacunae
Re-examine it.
or be for filling up lacunae. The learned counsel for the respondent, according to that the present is not of fit and should the tribal sub made on behalf of part have been duly considered and the materials is have been examined. The task of the petitioner in stating in making the present challenge in respect order dated 7/6/2020 is that specific averments were made in the regarding the two documents, which and in this regard, paragraph 14 of the was pressed into service. Order 8 would 1 of the Code of Civil Procedure is with regard to filing of written statement whereby a prescribed period whereby a period has been prescribed. Under Rule 1A you is cast upon the defendant to produce the document on which relief claim on which the relief is claimed. For any reference, the aforesaid provision of law is extracted herein below. The other rule under order 8, namely other relevant in order 8, named rules 3, 4, and 5 makes it clear that denial is to be specific and even an evasive denial is not acceptable. Therefore, the statement is sufficient made that adequate pleadings were made in the written statement would not do away with the requirement of filing the state documents along with the statement. And the only provision which gives a window to a defense is rule 1A within bracket 3. The requirement of the aforesaid provision is that leave of the court is required to be taken for producing such documents to be received in evidence. But in which this court, even without going into the merits and contents of the document, what intrigues this court is that as many as 8 days were fixed for defendant's evidence. And on 22/9/2022, the evidence of the defendant was closed. Full stop. At no point of time before the state date, any application was filed for seeking leave to produce documents. Full stop. This court is of the view that the contention now raised that the documents were mentioned in the written statement was available from the date of filing of the written statement, and no such prayer was made. The aforesaid observation of the court is taking a lenient view that though the present application, more particularly petition number 246 of 2013, has not been structured as a petition under order 8, rule 1A3, assuming the same to be a petition to seek leave, the state petition was not filed within the extended time. Full stop. What further confirms this court is the fact that both the orders dated 22/9/2022, by which evidence of the defendant was closed, and the order dated 12/12/2020, whereby the application for adducing additional evidence by the defendant was rejected, were matters of challenge, and therefore both the orders had attained final. After in that situation, whether the present two petitions in which the order at 7/6/2020 was maintained is itself a question. With regard to the submission that no reasons have been assigned, this court is of the that while rejecting petition number 237 of 237/01, the relevant provisions of law, named section 57 of the Indian Evidence Act has been discussed, has not only been discussed, but reasons have also been assigned for rejection of it. This court also finds force in the argument of the trust that since petition 237/01 was rejected, which was with a prayer for judicial notice, the second petition had become mere academic in nature, and therefore the impugned order dated does not appear one which has been passed without any judicial. This court in exercise of its supervisory jurisdiction under Article 227 of the Constitution of India would mainly be confined with errors of jurisdiction and would exercise its powers only in a circumscribed manner when there is material irregularity or gross illegality, and those conditions do not appear to be there in the present impugned order. That as regards case law cited by the learned counsel for petition, this court is in humble agreement with the law laid down. However, the aforesaid principles are understood with the facts and circumstances of each case, and in present case, exercise of the supervisory under Article 57 of the Constitution cannot be just. In that
I'm deeply obliged, ma'am.
All right.
Let me retain those two copies in the record.
we'll have it in
I'm deeply.
So the petitioner here is the defendant, the title suit filed by the respondent for a declaration of right to interest and transformation of position.
Petitioner is the defendant.
Yes.
Suit for
Declaration of right, title, and interest,
Hmm.
and confirmation of possession.
Yes.
But the trial of the in the suit commenced in the year 2018 when the first date was fixed for
2018.
my lord.
Suit institute.
Was fixed for evidence. The trial commenced.
It was fixed for evidence.
Yes, my lord. Of plenty of witnesses. And as many as more than 10 dates were taken for filing the PW witnesses. And after all, my lord,
Yes.
filed a petition. The plaintiff filed a petition under order.
On this 10 days, none of the PWs are reduced,
No.
not even chief.
The chief, they have adduced
They did not appear for cross-examination.
cross-examination. When we were waiting for cross-examining the plaintiff witnesses,
Yes.
in between 3 dates gone by, but the plaintiff witnesses were never being presented before the court for cross-examination.
On 3 days.
Yes, my lord.
Ultimately, did 10 numbers of PWs they post? They accused their chief.
Chief, my lord. But interestingly, in between when we were waiting for cross-examination of the PW witnesses, the plaintiff filed a petition for calling some records from the of a case pending before a different court for adducing those documents as evidence. And the learned court, my lord, by its order dated 10/8/2023,
Yes.
allowed the prayer, which is available at page 21.
What was the petition for?
Well, petition for calling for records of a different case pending before learned Munshi number 2.
Yes.
And the prayer was made by Lord much later than the prayer made by me for dismissal of the suit for non-prosecution as envisaged under Order 8 Rule 10. Well, when the evidence is sufficient on the record and the cross-examination is not done, no witnesses are being presented for cross-examination, the court can either dismiss or allow the suit on the basis of the documents and the pleadings available on record. But the court, on the contrary, allowed the prayer of the petitioner. But I filed the petition much prior in time than the petition filed by the plaintiff. My prayer was for dismissal of the suit. But when the case was fixed for a necessary order, if I may take a lordship to page 98, 98, last page. The order dated 21/7/2023.
Just
2023. I filed a petition being petition number 156/2023 for dismissal of the suit. Filed the learned counsel for the defendants, wherein prayed to dismiss the suit for non-prosecution, showing cause therein. The hard and pay was fixed 10/8/2023 for necessary order.
Yes.
And before that, if I may take your lordship to page 96. Six, order dated 26/4/2023. If I may read, my lord. Both sides are represented. Counsel for the plaintiff has filed evidence on affidavit of PW3 and PW4 along with copy. Furnished copy to the defendant side. Counsel for the plaintiff has verbally submitted that they will not submit any more evidence on affidavit. Accordingly, PW evidence is closed. And after that, my lord, I filed that particular petition. Just now I have shown the order. The necessary 10/8/23 was fixed for passing necessary order on my petition. But in between, my lord, on 10/8/23,
Yes.
the plaintiff filed another petition, which is available at page 67.
Yes.
This is the petition filed by the plaintiff. If I may read, my lord.
Hmm.
That miscase number so and so was fixed
When was this filed?
my lord, 10/8/23.
Petition by plaintiff.
Plaintiff, my lord.
Yes.
That mid-J case number so and so was fixed on 9/8/23. And next date is 26/9/23, pending for disposal before the court of Munshi number 1. This is a different case, my lord. At Tejpur, where some original documents pertaining to be exhibited, in this case, lying in the said case record, being exhibit document, but the staff could not hand over the same to the plaintiff due to some reason. That the plaintiff submitted his evidence in his case, but crossed not over due to lack of exhibit properly. Done so, the plaintiff with this petition praying for call for the record of miscase number so and so to this honorable court, just for exhibit those documents in this case by this honorable court. Today is fixed for necessary order in miscase number so and so. So the prayer was made. This is the petition filed by the plaintiff on 10/8/23. But prior to that,
Yes.
I filed a petition on 21/7/23, which is available at defendant filed a petition on 21/7/23.
Yes. Where is it?
Which is available at page 65 for dismissal of the suit for non-prosecution.
It was on 8/10.
No, my lord. The second petition, the defendant filed, 10/8 petition was filed by the plaintiff.
No. Your petition was the order date.
No, my lord, though no provision is quoted here, but it is presumed to be filed under order 7, rule 2 and 3. Because when evidences are, my lord, sorry, order 17, my lord.
Now you have said that order 8 would stand petition had filed.
No, I
Would have
said,
been
my lord, the court has the power to dismiss the suit under order 8, rule 10. If prima facie there are documents on record or some evidence are filed. And the petitions, my lord, which is presumed preferably to be filed,
What is the submission on 21/7/2023? You had filed a petition for what?
for dismissal of the suit for non-prosecution.
Yes.
And the date was fixed for 10/8/23 for passing necessary order on this petition. But interestingly, my lord, if I may take your lordship to page 20, the 10/8/23 was fixed for passing necessary order on the petition filed by the defendant for dismissal of the suit.
Yes.
Both sides are represented. Your lordship has got.
Yes.
Seen the petition number 1696/23, wherein the learned counsel for the plaintiff prayed for calling of the case record. Now, this is the petition filed at the later stage, my lord. Pertaining to mid-J case number so and so pending at the Court of Civil Justice, Junior Division number 1, Sonitpur, Tejpur. It is stated in the petition that some original documents attached with the case record are relevant in the instant suit and thus required to be exhibited. Heard the learned counsel on both the sides. I have perused the case record. Considering the contents of the instant petition, the case record of mid-J case number so and so pending at the Court of Civil Justice number so and so, Tejpur is called for in connection with this instant suit. DA shall take steps. Accordingly, the instant petition is disposed of fixed 28/8/23 for record. To this extent, my lord, it was all right. But later on, my lord, on the same day, after the court hour was over, later on the relevant case record being mid-J case number 15514 is received.
Yes.
And the original document sought to be exhibited in this suit.
Yes, we have read. That is your endeavor to get the your petition could have been rejected as a different matter.
Yes.
But your endeavor to get the suit rejected has been preempted by an order passed in a petition filed subsequent.
Subsequently.
That's the one.
Yes. Not only this, my lord, the learned court with utmost humility and respect, my lord, could not have acted on behalf of the plaintiff in accepting those documents from the record. It is contrary to the provision of Order 13 Rule 10. The learned court could have inspected those documents and could have proved this document by calling witnesses. But it is when it is the bounden duty on the part of the plaintiff to prove the documents or exhibit the documents.
Suit is of which year?
Suit is of, my lord,
2014.
2014.
Why to say that suit was suit is 2008?
No, my lord. The 2018 trial comments. The first date for evidence was fixed in the year 2018, and he finally completed the evidence in the year 2023. But later on, he started filing petition one after one, my lord, citing this reason or that, avoiding cross-examination of the witnesses.
Will issue.
So it-
Yes, the student counsel for petition. Where I being active by noted 10,800 pass in petition number 19 public 2000 in connected title 90 by the civil judge package number by state.com the bill by call for the court another has been out and the petition filed with petitioner defense is the suit not has dismissed has been rejected. You are not agree by your rejection.
I am not agree by the rejection, but I am
Present revision, however, confined to allowing petition number 1696 of the plaintiff.
if I may interrupt, okay, if I may interrupt, my lord, I am not really agree by calling for the records, my lord. I am agree by the later part of the order passed on the later stage, whereby the documents itself were exhibited. If I may take your lordship to the proved in original with the compared copies.
If the student has a that reverse is made that part of the order by which the requirement of by approve of the document by in accordance with law appears to have been done. That notice written by 4 weeks that step taken for service of sold on by that step by but the next is
My lord, 31/10/23 for the documents, my lord. Documents were already submitted and exhibited.
30
31/10/2020.
31
10.
10. That and has contributed and has informed it that the next step in the court below is 31, 10,
2023.
that for consideration on everyone
13th,
October
13th of
for- can you serve justice?
yes.
Serve justice.
Obligement.
My lord, OP, my lord, file appeal, my lord, against the order passed in my petition filed under, my lord, section 11 of CPC, taking ground of res judicata, my lord.
You are whom?
I am the petitioner, they are plaintiff.
no.
In the court below, plaintiff.
You are the defendant.
Plaintiff,
You are the petitioner is the plaintiff.
yes,
Petitioner is the plaintiff.
my
Suit for
suit for my lord, declaration and recovery of possession.
recovery of
Right.
Yes. What happened?
My lord, my humble submission is that, my lord, on the order rejecting, my lord,
What had happened?
my lord, the
There was an earlier case.
earlier stood under section 6 of a specific relief act. That suit was dismissed.
Earlier suit under section 6 specific relief act was dismissed by defendant. By defendant.
By court.
No, that was by
It was
defendant.
by plaintiff. Plaintiff, this petitioner.
No, earlier suit.
Yes,
Your suit
my lord, my our two persons.
was dismissed.
Subsequent suit was filed, my lord, is a regular suit for declaration.
Which is the present suit.
Yes, it is a present suit. And which is not a, my lord, bar.
Yes.
In the second suit, my lord, they filed a petition.
For adjudicata.
Yes. And that their petition was rejected. Can you see, my lord, this order is there.
Rejected when? Rejected by trial court.
Rejected by trial court, page 14, my lord.
Date?
Page 14.
Date?
Date, my lord, 25/5/23.
Then they had gone for appeal.
Yes. Appeal, my lord.
By defendant. Where is the appeal put out?
Yes, my lord, page 29.
59.
Yes. My lord, here is true, my lord, true submission is there. Number one, my lord, against said order, no appeal lies. My lord. No appeal lies under order 43, my lord. Of CPC.
No. At 29, what is this order? At
Yes,
8,
page
9.
29, page 29.
Yes.
Yeah,
Let us read the order.
it was the condonation order in
Yes.
the appeal. My lord, condonation petition was allowed.
Yes.
And appeal file, appeal already numbered. My lord, I have
Only the delay has been condoned.
my lord, delay condone. If my lord appeal is not maintainable, then delay also does not lie, my lord.
No, the maintainability of the appeal, that question has not even arisen.
My lord, if their district judge has no jurisdiction, then my lord, no, my lord, a condonation petition lies there.
The appeal is yet to be admitted.
still, my lord, but my lord, by I
We are only concerned with the decision which has been passed in a delay condemnation appeal.
my lord,
You may be very right in contending that there is no appeal provision.
Yes.
You may be right, but that appeal is yet to be admitted. There has not been an order of admission.
That's right, my lord. I have also challenged the maintainability of my lord filing appeal and
Has an order been passed on your maintainability issue?
my lord, since my lord, the condonation, my lord, or to dispose of my lord condoning the delay. And I file objection, my lord, not a line, my lord, no history even there, my lord, mentioned about my objection.
The condemnation application has been disposed of on 8/9/2023 by certain reasons and saying that lenient approach is taken. We may not find fault with that, but if the appeal is admitted, before admission you have the right to object. Appeal is not maintainable. If your objection is rejected, come for us. At this stage, how can we enter in the aspect of maintainability?
Because my lord, this already appeal registered, my lord, and in the wrong.
Has it been admitted?
Not admitted by.
Is there a judicial, has any finding been given by a judicial court on the maintainability, on the admissibility of the appeal? May I raise has the appeal been admitted?
My lord, the next page, the order on pass, of course, with my lord for filing objection.
Yes.
Next page, my lord, page 30.
Yes.
It is from my lord online order.
Next purpose objection, file an objection, raise the question of maintainability. Matter ends there. If you say that an order by which an application under section 11 has been decided is not an appealable order,
Not appealable.
and yet an appeal has been filed, you point out the court
Not appealable order and my lord, jurisdiction, question of jurisdiction also.
to raise that. We close this by giving you liberty.
Liberty zone
Which
there, my
should,
lord.
which should be decided in accordance with law. Liberty to raise appropriate objection on maintainability. You want to withdraw?
My lord, that's right, my lord, but my lord.
No, Mr. Chauhan, unless there is an order, there is an application of judicial mind. Can we preempt somebody?
My lord, I raised the objection. Can you see, my lord, my objection?
Objection was only in the condemnation petition.
In my lord, condemnation petition itself, I have raised the objection. That question.
That petition admissibility was not put forth.
No, my
It
lord.
was
In the
only
court below, in the court below, my lord, while I file objection, my lord, page 24.
Mr. Chauhan,
My lord.
before a delay is condoned, does the court assume jurisdiction? Answer is no. Now the delay has been condoned, the court will exercise jurisdiction, and while doing so, you point out to the court that appeal is not maintainable.
The lord question of jurisdiction in the condemnation petition itself, my lord, raised.
But
I
was
have
that the
expected-
issue? Can the court put the aspect of condoning the delay?
My lord, in the condemnation delay, jurisdiction can be seen, my lord. I have raised the question there.
What is the issue before the court? Whether the delay has been condoned or not? Court has said that we condoned the delay.
My lord, if
Court has not said that
my
the
lord, if
appeal
the
is
court has
admissible.
no, my lord, power, no jurisdiction, my lord, why condemnation, my lord, will be entertained, my lord? I have raised a specific question there that
Then if you are
not
insisting, then we'll reject your third three S200 when it comes for the petition who have filed petition under Article 27 of the Constitution of India. Being aggrieved by an order dated 8/9/2020 passed by the learned restricted from a Karbi Anko in May 11 of 2020. That the petitioner is the plaintiff in the suit filed for declaration and recovery of possession. Case of the petition that on an earlier occasion, the petitioner had issued a suit under section 6 of the Relief Act, which was dismissed and subsequent, the present suit has been filed, which has been numbered as title suit number
That is the number 4 of 23,
4 of
20,
20,
22,
4 of 2020. It appears that the defendant had filed a petition raising issue of res judicata, and by it ordered it 25/5/20, the state petition has been rejected by the learned trial. However, the order was a subject matter in an appeal preferred by the defendant. And as state appeal, and as there was delay in putting the appeal, an application under section 5 of the Limitation Act was filed. That the learned district judge, Karbi Angrong, by the order dated 8/9/2020, has condoned the delay and submission number 11 of 2020 was accordingly. With the contention of Sri Chauhan, the learned counsel for the petition, that appeal itself is not meant to, and therefore the order to 8/9/2020 time is prepared. This court is of the opinion that a matter wherein there is delay, unless such delay is condoned, the court will not assume any jurisdiction. This court has also said that the appeal has not yet been admitted, and the present petition would have all the scope and opportunity to raise the question of maintenance of the appeal, and that stage has not been come. The order dated 8/9/2020 of condonation of delay does not prima facie appear to be an order which has suffered from any material irregularity, and rather the order is based on sound legal principles concerning the aspect of condonation of delay, where a pragmatic and justice-oriented approach is necessary. In view of the this court took that the present is premature and without any cause the same.
This division is preferred before Lordship by adjourning the execution proceeding which is pending against the present petitioner. What happened in this case, my lord? There was no notice issued to the judgment debtors prior to initiate.
Petitioner is the defendant.
They were defendant,
Defendant judgment debtor.
my lord.
Judgment debtor.
Yes.
Suit was for
Suit was for declaration of right, title and interest over the suit plan and possession.
and recovery. Recovery.
Actually, the suit land bars the jurisdiction of the civil court. It is a exonia land.
That we cannot enter.
Yes.
Now
But
that
we-
was put to execution.
Yes.
Yeah.
Now, What happened in this?
When was the decree?
No,
Decree when?
decree on 23/6/17. 6/17
Decree by which court?
by Civil Judge Borpeta. Annexure 3, operative portion 41.
Okay, then
Then, my lord, they have filed on 11/12/17 an execution petition, which is annexure 4, page 42 onwards. Type copy. 42.
execution petition.
Since, my lord, your lordship will, if you peruse the record of proceedings of the state execution proceeding, which has been subsequently transferred to the learned Munsi Baksa for execution in the month of, on being commencement of operation of business of the courts in Baksa district, no notice was issued by neither by the learned executing court of Baksa, Barpeta, neither nor the present executing court, to which cause gave prejudice. So on the other hand, my lord, another important factor is that the present petitioners could not prefer any appeal due to non-communication of the outcome of the said appeal by their engaged counsel at the relevant time. And they have just prepared a revision petition before this honorable court with a condemnation petition, which is yet to be numbered
Revision against what?
against the said judgment of the learned civil judge.
Decree.
Yes.
Revision maintainable.
Revision also already yet to be numbered.
Revision is maintainable when
Not appeal
right.
paper.
when appeal is prescribed.
Because RSC is not maintainable because considering the shoot value. Shoot value has been
Why
shown.
arrested? First appeal.
Shoot value has been
No,
given.
why arrested? How do you go to second appeal? What about first appeal?
First appeal has not been done, my lord.
Is it a regular decree?
Yes.
Why first appeal is not? Let us not go into that aspect.
That
What you content on
now
the
on-
notice part?
Notice part what I am submitting.
Let us
before-
say order
Order lordship will find at 11 and 12.
page 11.
No, annexure 9 and 10. Page 51. 51 is the type copy.
Yes.
It is the order sheet of the initial order sheet. Is filing of the execution petition. Lordship will find.
Forfeiture.
Yes.
Then?
Then no notice was issued to the judgment debtor. Thereafter, I have annexure 10. Annexure 10, 11, sorry, 10, yes. It is the orders of learned Munsi Baksa.
Page?
Page 58.
How did you know about this?
When the concerned officials of the executing court visited the shootland for verification and for collection of report with regard to eviction. So immediately we rushed to the concerned court of Barpeta, thereafter Baksa. And
But the last order 77/2023.
Oh.
The decree holder is represented. Page 62.
decree holder is represented, but
In
we
the
have,
report of the civil agency, it is
Yeah.
stated that the decree could be executed due to non-cooperation of the decree holder.
decree
And
holder.
decree holder is directed to take first step
Yes.
and cooperate with the civil agency.
But
Unless the service is complete, why it active? You're not even.
No,
served a notice.
Lordship may kindly peruse the impugn order, which is
The moment you come to this court, you can presume that you have critical notice. We'll send you back to here on a particular date.
no, that is other aspect. Lordship may kindly peruse the impugn order, page 50.
50.
Yes.
Here. Eight, nine.
All
Yes.
right. Herein decree holders are represented. I have heard the learned counsel for the decree holder. Learned counsel has deposited rupees so and so towards the police cost for execution of the decree in regard to the same challan bearing number so and so is also submitted before this court. I have also perused the entire case record carefully. Accordingly, civil judge is directed to take necessary steps for execution of the decree with the help of police. Police, revenue authority, and the local administration.
You are challenging 8, 9.
Yes. And today is the date for eviction.
What has happened?
Report. Now, so far as my inspection, nothing has happened till now. As of, and we have filed an appropriate petition before the court with regard to pendency of this proceeding before your lordship.
Now you are in notice now.
Yes. And more particularly, if the learned executing court would not commit any error in issuing notices, the peasant petitioner, there was no occasion arose for the peasant petitioner to file appropriate appeal at the relevant time, immediately after passing of the order. Their counsel committed some wrong thing, that is other issue, but immediately after passing of the order, at least filing 11, 12, 17, or in the month of, in the year 2017 would have been issued, would have been served upon any notice with regard to execution. Definitely, we may approach for filing an appeal. Because in the Shootland, we are residing since last 50 years. And entire.
No, that cannot go behind
That
the
will
decree.
go,
Now,
that
decree
is
has
court-
been
Yes.
decree has been passed.
Yeah.
That can be looked to only by a civil
Yeah.
by an appellate court.
Only error occurred in this case, issuance of notice, which is violation of section 105, order 21 of the.
You will can you serve dusty?
Those-
Your stand is there. You can serve dusty.
primary.
Serve dusty. But on the next date, we are having doubt on the effect of notice.
But
Currently, it occurred the A park done it for petitioner. Petitioners who have filed under Article 27 of the Constitution being active. And ordered it 8, 9, passed by the London Pakistan in that section 05/01, whereby the civil Nazir has been directed to carry out eviction of the petition from 29 that I today. The petitioners were the defense to file for declaration of right and for the suit was filed on page 3627 by the learned Supreme of Corporate and on page of the new district of Pakistan and Sultan with territorial limit new district, the execution was transferred
To the
to
district
the
of
appropriate court at Pakistan.
from Borpeta.
Is the specific the all has wanted that at no point of time and this was received by the petition either from the court at Corbetta or subsequent from court from the court at Baksa. It is only when certain officials had visited the suit property from the petitioner could know about this. That note returnable on 11th of October. That petition by Monday. The petitioners are also required to step for service by the state, which is required to with the registry of court. Also, the notice accompanied should clearly reflect the next is fixed, that is 7/10 of the month. The petitioners are also required to file it prior to the next date in proof of such justice. File the account is for considering that the materials is put forth do not indicate that was issued or served upon petition from with the direct till the next date from further proceedings. You have not paid for further proceedings.
Wait, man.
Where?
Lordship, kindly prayer.
Prayer, what prayer? You only paid for stay of the order.
Stay of the impugned order. Operation.
What
Yes,
impugned order?
pending, page 18, madam.
Page 18. Where is the prayer for stay of the proceedings?
Pending disposal of this petition, Lordship may please to stay the operation of the impugned order so it's passed in.
We stated order will be serve your purpose.
But in addition to, it is.
What do you want to say? You want stay of the execution proceeding.
I have also prayed for necessary orders to that effect as your Lordship may deem fit and proper.
By making a prayer, you should apply your mind. Don't just mechanically say order this to say. Will get the order. Let them execute. Further proceeding in title execution case number 5 of 2009. Pending shall remain. It is, however, made clear that since the interim order has been passed expert from the respondent may come up for alteration. But it is further the interim order passed on the next day. Nine.
May it please the Lordship.
Madam?
Lordship, in this case, the petitioners are the degree holders. Lordship.
You are the plaintiff.
I am the plaintiff for degree of specific performance of contract.
Sure.
From pro forma respondent number 6.
So for specific purpose
Yes, Lordship.
of contract.
Yes, Lordship. From pro forma respondent number 6, Mustamat Naikul Nessa Borbhuiya. So my suit was decreed. Accordingly, I have filed one execution petition. The present respondents, the main respondent filed an application before the executing court, annexure 1, page 12, Lordship. Objecting to the execution proceeding.
They objected.
Yes, Lordship.
By whom?
By the present respondent, Lordship.
Yes.
They objected in para 4. They have stated that the petitioners are the sons and daughters of Moina Mia Borbhuiya and they jointly inherited 4/5 share of the property left by late Halima Bibi Bormuya. That the
Where is
decree
the impute order?
impugn order, Lordship, I filed and after filing this objection before the executing court, I have filed my objection and that objection is pending for adjudication. In the meantime, they have filed one title suit, Lordship, on the same grounds, Lordship. So I have filed raised an objection that the plain to be rejected, Lordship, as already they have filed objection in the executing proceeding, Lordship. That my rejection prayer was rejected by the Honorable Trial.
How do you bar a new title?
Lordship, 102 says
No,
not
no,
by a
what are your
separate suit.
grounds? What are your grounds? When a decision can be challenged in a title.
But Lordship, at the same time, they are objecting in the execution proceeding by Order 21, Rule
Will
97.
that,
And 102 says there is a bar, Lordship.
100,
Order 21, Rule 102.
so if there are certain elements of fraud or something, they can challenge separate suit.
So they cannot take the both recourse, Lordship. In one way, they are objecting in the execution petition, and another way, they are filing the Lordship. The second.
If they do not object, the execution proceeding will, then what will remain?
No, in that case, Lordship, if they prefer suit, Lordship, then they are required to file a suit and take an injunction.
Yes.
Then that injunction order is to be submitted before the executive court, Lordship.
That they have done.
No, Lordship, they have,
Only because they have
first
filed,
they have filed objection, Lordship.
only because they have filed an objection. Will
Lordship,
it preclude them or will it be a disappear?
Lordship may
Cannot be
kindly
a-
see order 100, order 21, rule 100, Lordship.
You said
102 is later on, it will come, Lordship, and questions to be determined by the executing court, that is 101, Lordship.
Yes.
100 says, Lordship, order to be passed upon application complaining of disposition. So any order passed by the executing court, any objection raised by any of the parties is to be decided by the executing court itself under 100, Lordship. And then 101, Lordship, questions to be determined, all questions including questions relating to right title or interest in the property. That is the prayer of the present respondents, Lordship. Arising between the parties to a proceeding of on an application under Rule 97 or Rule 99, or their representative and relevant to the adjudication of the application
we
shall
have
be,
to, we have to
Lordship. Application under Rule 97 or Rule 99 or their representative and relevant to the adjudication of the application shall be determined by the court dealing with the application and not by a separate suit.
Yes.
And for this purpose, the court shall, not sending anything to the contrary contained in any other law for the time being in force, be deemed to have jurisdiction to decide such questions.
Yes.
So this there is a clear bar in 101, and moreover, Lordship, Section 12. Section 12 says, Lordship, where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action, he shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies. So now my question, whether his suit will be maintainable, Lord. And the learned trial court rejected our application.
Madam,
Side-
the basic objective of this provision is to protect the interest of third party.
No, Lord, any party, third party, Lordship, but when he taken the step for filing an objection in the execution proceeding,
Hmm.
now he is precluded from filing any further suit, Lordship.
But
There is a complete bar, Lordship. And executing court, there are so many decisions of Supreme Court says, Lordship, executing court is the competent authority to decide right title interest, even for a third.
right title interest
Yes, Lordship.
in a third party, that's under 21, 101, 102.
Yes,
Not
Lordship.
this is in respect of the decree holder and
I-
judgment debtor.
We are, no, Lordship, we are the decree holder. Judgment debtor is also, Lordship, executed the sale deed.
Hmm.
For that execution is pending. They are
The
third
party
party.
which have filed a separate suit
They are
was
third
the
party.
party original. They are not third party.
They are third party, Lordship. They are not plaintiff defendant in the earlier suit, Lordship.
You said they are the judgment debtor.
No, Lordship. Judgment debtor is pro forma. I made her as pro forma respondent.
Objection filed by whom?
Objection filed by the decree holder. And that objection
No, no,
filed
no.
by
The
the third
objection
party,
against the execution.
third party, Lordship. They are saying they are the co-sharer of the property which was sold by the pro forma respondent in favor of the petitioners, Lordship.
But where is the bar? Is there any bar?
Yes,
not
Lordship.
that-
101 says clear bar, Lordship.
Is there any interpretation? And not by a separate suit?
Yes, Lordship. The learned trial court cited a decision 2005 GLT, Lordship. That is Kamakya. In page 70, your Lordship will find.
Third,
2001 5.
the third MS arts also. But petitioner who has filed this application under Article 67 of Constitution against an order dated 5/8/2023 passed by the learned civil judge within the senior division from Hailakand in Miss Case number 134 of 2023 arising out of title suit number 26 of 2023 whereby the petition of petitioners to reject title suit 26 of 2020 under order 7 rule 11D
Yes.
of the CP has been dismissed. Full stop. The petitioners were the plaintiff in the original title suit in which a decree was passed in favor of the plaintiff. Full stop. The suit was for specific performance of contract against the pro forma respondent number 6, correct?
Yes.
At the time of execution of the decree, the present respondent who were not parties to the suit had filed an objection
Under order 21, rule 97 and 101.
under filed an objection under order 21 rule 97 that rule 97 and 101 of the CP. Simultaneously, they have also filed a fresh suit challenging the decree. Full stop. MS Chaudhary, the learned counsel, has submitted that once a party takes recourse order 21 rule 97 and 101 is debarred from instituting a fresh suit in relation to the decree in question. Full stop. Let notice be written on October 11th. That step be taken for service of this upon the respondent by registered post date upon the respondent including the performer. You take the speech.
No, Lordship, registered post with it.
Registered we have to take justice.
Or ordinary Lordship, just see whether they will receive or not.
You can file a speech. Did not. Can you do it justice? The parties are
Lordship, Dusty, we can take Dusty upon the advocates who are representing them before the learned trial court. Lordship.
you tendered your
Lordship.
if they do not file an affidavit,
Lordship.
the petitioners are also got accepted by the state, which would, however, has to be to the registry of the and in the notice accompanying the next date, that is 11/10/2000, be clearly reflect the petitioners are also required to file an affidavit prior to the next day in proof of such justice.
Right.
Sarah? What is the stage?
Lordship, the suit will proceed now. So I have a prayer for stay of the suit, phase 10, Lordship.
MS Chaudhary, Learned Counsel, pays for an interim order. After considering the facts and circumstances and the provision of four particular order 21 rule 101 of the comma, it is direct that till the returnable date, comma, further proceed entitled to number 26 of 2026 before the learned civil judge written by the senior division. Shall remain suspended. Since the interim order has been passed, but the respondents we are able to come up modification as authorization to come up.
Oblige.
May I please, your lord?
Yes.
My lord, in this case, my lord, two questions have arisen. my
Item
lord.
10.
10, my lord.
Your name is not there, Mr.
No, no, my lord. My lord, Mr. Sabha, my lord,
Okay.
his name is there, my lord.
Doesn't.
Two questions have arisen, my lord. One is, my lord, whether, my lord, after a decree has been passed, my lord, the executing court can rewrite the decree, my lord, by incorporating a new schedule, my lord, which was not there in the earlier my lord, decree. And the second one is, my lord, whether, my lord, the plaintiff, my lord, while bringing a suit, my lord, is required to bring the, my lord, substantial and define the area where he claims, my lord, right title and possession substantially by putting the proper identification in the claim. Now, here in this case, what has happened, my lord, I as the plaintiff, my lord, I had,
Petitioner is the plaintiff.
yes, my lord, I as the plaintiff, my lord, I had received,
One petition.
yes, my lord, no, my lord,
Petition.
yes, my lord,
Petitioner or plaintiff.
yes, my lord.
Suit for
Suit initially was suit file for, my lord, recovery of area rent and eviction of tenant, my lord. Under the procedure of the Assam Urban Area Rent Control Act
an ejection.
and ejectment, my lord.
Then to decree.
No, my lord. Then, my lord, while filing the written statement, a counterclaim was filed, my lord, by the defendant, saying that he purchased an area of land, my lord, 2 katha 10 hectares from my grandfather. And ultimately, on that basis, my lord, the matter was adjudicated, and my plaint was dismissed, suit was dismissed, and a counterclaim was decreed, my lord. Now, after, my lord, the counterclaim having been decreed, my lord, on the basis of the, my lord, schedule which is given in the plaint, the decree was put to execution. And when the decree was put to
The
execution,
defendant.
they had put they are counterclaimants, my lord. So they had put the decree to execution, my lord. Now, after putting the decree to execution, they themselves come up before the executing court saying that the schedule of the suit land which we had given was erroneous and it is not properly identifiable. So the decree has to be rewritten. First, my lord, there were two petitions, my lord. Under Order 6, Rule 11, saying that amendment of the decree by the executing court. Thereafter, my lord, rewriting the decree by the executing court, my lord.
Where is that?
That, my lord, lordship finds at page, my lord, 101, my lord. It starts with this petition at page 101. May I read the petition? my lord? Yes, please.
101,
Yes, my lord, page 101.
101.
Yes.
Yes,
May I read the petition, my
yes,
lord?
please.
Petition under Order 6, Rule 17 of the CPC. The above named petitioner most respectfully begs to show it as follows. That while filing the above noted execution case, the schedule of the land was described as it presently stands in changed condition, and as such, it did not tally with the description of the schedule of the decree in toto. That now it appears that in the process of
Yes,
execution,
then thereafter,
my lord,
thereafter,
thereafter, my lord, there is, in this petition also, they have not given the schedule. Then thereafter, they file another petition, my lord. That is at page 103.
it would be
103.
Yes.
In this, my lord, petition, if the lordship, my lord, kindly see
that
that,
earlier petition order 6 rule 17 so called,
yes, my lord,
under which, on which date?
that is, my lord, on 22/2017,
20,
02
20th of February
2017,
17.
2017,
Then at 103,
4/8/2018, 2018.
this is under 151.
This is under 151. Now kindly here see the language, my lord. That from the report of the bailiff submitted today before your honorable court, it appears that the concerned Latmandal is finding it difficult to draw out the actual suit land from the schedule of the decree. That in view of the alleged ambiguity, it becomes necessary to rewrite the decree to reflect the true intention and spirit of the judgment for execution.
Where is the order?
My lord, impugned order, my lord. Thereafter, there are some other petitions, my lord.
No, where is the order?
Order page 123.
1 to 3.
1, 2, 3.
Where is the correction here?
My lord, the correction that is there in the, my lord, draft deed, my rewritten deed, which they have submitted,
No, in the order,
my lord.
we can accept the so far as the petition filed under order 6 to 17 or under 150.
My
There
lord.
is no scope. We can,
Yes.
for the time being, let us assume that we are,
Yes, my
but
lord.
this order,
My
which
lord.
you are presently impugning,
My lord.
there is no part, which part of the order is in connection with changing the decree?
No, my lord, now that this order doesn't reflect that. My lord, prior to this order, my lord, a draft rewritten decree had been submitted, my lord,
By
by the decree holder. And on the basis of that, my lord, without, my lord, giving me notice, my lord, without,
where is the draft?
draft is here, my lord, at page, my lord. It starts from page 109,
109.
9, my lord.
Yes.
By this draft, my lord, this draft is a rewritten decree which has been submitted to the court, my lord. To the executing court.
And this has been accepted.
Yes, my lord. It has been accepted, and my lord, without even noticing me, my lord, without hearing me, my lord, and giving me any opportunity, this order has been passed, my lord, by which the decree is sought to be executed over land which is other than which is there, my lord, in the schedule to the counterclaim.
Now, by the order, what is
My lord, the decree is not to be executed, my lord, that
page,
incorrect
page,
draft.
page 150?
123, my lord. 11/8/2020.
What is the ultimate direction?
The direction is to, my lord, execute the diary decree and to, my lord,
Date has been fixed,
yes, my lord,
39.
30/09/2023.
Third, Learned Counsel petition to have right under Article 7 in respect of order 11/8 of the petition caused by the learned judge,
District judge.
learned district judge in right section 3 of it, whereby the petition court to aspect dated 23 of the but of the response has allowed and directions for a of the petitioner were in a style for proof of area rent and reject. The defendant were respondents hearing in the written statement, along with the written statement, had also filed a counter. So counterclaim wherein it was stated, wherein it was claimed that an area of 2 land was purchased. Consequently, the suit was dismissed while the counterclaim was declared. At the time of execution, the defendant had considered that the schedule in the counterclaim was erroneous, and therefore the decree was required to be read, and in this connection, separate applications were filed, one under Order 627 on 22/2017, and another under Section 1 of the statute on 4/8/2008. It is further submitted that subsequent a draft rewritten decree was submitted by the respondent, and based on the same the impugned order is passed. The contention of the learned counsel that the role of the court is strictly confined to the and cannot go behind the scene. Yes, can you take the sitter with?
Yes, ma'am.
We'll have it on 11th of October.
My lord.
Have registered proceedings on
My-
it. Can you file the affidavit?
Yes.
The next.
Yes.
We thought that the learned counsel pays for an interim considering the and the principles of law holding footage of the opinion. This code direct and this code comma it into the direct that until the returnable date. The implement order date 11/8/2020 passed by the learned district judge Kumar Dhemaj in title and system 3 of 2015 shall remain.
Further proceedings also.
Come up for
I'm deeply. My lord, steps within 3 days, my lord,
by month.
by month.
May it please your lordship.
Yeah.
Lordship, in this case, I am the accused in a land grabbing case, lordship. I have set up my written statement with the defense that I have purchased the suit land and these are inherited land of our
Sorry.
predecessor.
You are who?
Accused in a land grabbing case, lordship.
You are an accused.
Yes.
But just,
So we filed our written statement.
just. Petitioner is yes.
It is the allegation of the complainant that in the year 2021, lordship, we have entered illegally over the suit land and lordship occupied the suit property. So lordship, and land grabbing proceeding was initiated, annexure 2, lordship, let summons be issued to the opposite parties to submit their written objections. If
In land
any.
grabbing case, CRP is maintained.
Yes, lordship.
Not a quasi criminal.
No, lordship, 227 is maintainable. Lordship. Let summons be issued to the opposite parties to submit their written objections, if any, for determination of question of title, lordship. So we have filed our written statement.
When?
It is annexure 3, lordship, that was filed on.
Statement filed by petitioner.
Yes, lordship, all the petitions,
How many petitioners?
13 petitioners.
13.
Yes.
You-
We have filed our written statement on 22/3/2000.
Common written statement.
Common written statement. Some say that we are inherited some purchase like this, they are
Common
occupying.
written statement by all the
Yes.
petitioners.
Yes, lordship, 13. Only accused number 1 did not contest it, lordship. So
Except one.
except one. So I made him
But
party as,
he is not a petitioner.
he is not petitioner. I made him party as pro forma.
Doesn't matter. Then petitioners have participated.
Yes, lordship.
Yes. Then
So
total,
we,
that means total 14 accused were there.
yes, lord.
And out
14
of them,
accused.
13 have come.
13 have,
And they have participated.
all
proceeding.
of them filed written
Then
statement.
what happened?
Then lordship, the charge was framed by the learned tribunal
Hmm.
on 21/1/2021, lordship. Cognizance was taken, lordship.
Yes. Yeah.
Then we were directed to file written statement, then we filed our
You
written
filed it,
statement,
yes.
and then the complainant filed 3 PWs, lordship. 1 PW was cross-examined, 2 PW was cross-examined. Then the lordship, due to paucity of time, 3rd PW cannot be cross-examined by the petitioners, lordship. Then lordship, a new member came and he fixed the case, saying that criminal liability will be decided first. Page 53 is the order dated 16/5/2023.
56.
53, Lord.
Yes.
Before that, your lordship will find in page 52 that cross-examination of PW3 stands adjourned due to paucity of time.
Yes.
So civil liability was, lordship, going on, it was not decided finally. Then suddenly on 16/5, new member came and a new chairman came and he says, lordship, that in a case under Land Grabbing Act, to decide the civil liability, the tribunal court need not to go on detail. Law is clear that it has to decide the civil liability of the informant complainant summarily. It does not decide any right, title, and interest of the parties. It just shall decide whether the informant complainant has prima facie case to proceed with a criminal case under the provision of land grabbing or not. So 3/6/2023 was fixed for necessary order. On 3/6, there is an adjournment taken. And lastly, on 1/8/2023, impugn order was passed.
1/8.
2023. Page 55.
What is that? What's the order?
That is a long one, but may I read the entire?
No, not.
Page 56, your lordship will find if the tribunal concludes its decision in positive. Page 56.
Letter,
Second paragraph.
yes, it's 53. 53.
53, 55 is the impugn order.
Yes, we have seen. We come to 56 now.
Yes, lordship. 56, if the tribunal concludes its decision in positive after deciding the civil liability of the parties summarily, then it would come to conduct the trial of the accused as per provisions of the Act. It is also to bear in mind that it is only when a plea is taken or a defense is sought by an accused that he has a better civil claim over the land in question. The special tribunal shall carry out determination of civil liability, which is for a limited purpose, before going to the criminal trial of the case. Such provisions has been kept by the legislature.
Yes.
Its wisdom perhaps to ensure that the accused is not wrongfully prosecuted.
Now,
by
what is
the
your case? That even before the cross-examination of PWC was over,
Without concluding that
civil,
civil
the-
liability, the court cannot proceed
the
for
learned
criminal.
presiding officer comes to a conclusion that the civil liability was discharged.
Yeah.
And we have proceeded on the criminal.
Criminal liability. So this is my case. So this is complete illegal here, lordship. And
But with the prima facie satisfaction, what about the
no,
examination
lordship,
of
the Supreme Court says even the adverse possession plea can be taken up by the special tribunal, as it is a special tribunal constituted under a special act. It has to decide the defense of the.
no, that we have accepted. But see, there are 3 witnesses.
Yes.
1, 2, and 3.
Prima facie, it says PW1 says he is staying over his purchased land. So prima facie, it is proof that.
Now, is your case that even with the materials which have been gathered by the tribunal, the prima facie satisfaction could not have been arrived?
Yes.
That is your
Yes. Without any finding, lordship. Either he has to find that we have no defense like civil liability, lordship. Then only
Heard,
we will be
heard.
prosecuted.
MS out for the counsel for the petitioner who are aggrieved by an order that 1/8/2023. Petitioners who have filed the present petition under Article 227 of the Constitution of India, being aggrieved by an order that is passed by learned
Presiding officer, special.
the special tribunal. What do you
Yes, the presiding officer, special tribunal, Morigaon in special tribunal.
presiding officer, special tribunal, Morigaon, in session special
Tribunal.
within bracket LG, case number 01 of 2001. The petitioners who are 13 in numbers were accused of land grabbing upon being recognized by the order 21 March 2021. The accused petitioner had filed a common writ denying the allegation and also project that they are in lawful occupation.
Except accused number 1.
We have that petition. The first part had adduced evidence of 3 numbers of it, and the order did 6 3/2020 passed by learned tribunal would reflect that while two numbers of PW were cross-examined, due to paucity of time, the third PW could not be cross-examined. However, on subsequent change of the presiding officer, an order has passed 16/5/20 to proceed on the aspect of criminal liability, followed by the issued order dated 1/8/2023. That the learned counsel for the petition has submitted that the materials on record which were before the learned tribunal up stage of cross-examination of the two PW cannot bring one to the conclusion that the civil liability was properly discharged by the first party. It is contended that unless the tribunal is emphasized on the civil liability, on the charge of civil liability, the proceeding cannot be taken ahead on the criminal part. That notice of returnable on 13th of October. Can you take steps by the state?
Lordship, can it be on Wednesday 11/10? Or
11/10 we can you have it by the state?
yes, sir.
Okay. Register posted daily as well as the
Lord.
The order stated on it department. May come up. Yes.
Further proceeding has been suspended
Yes.
or obliged. Your Lordship has suspended the order
We have suspended the order
1/8.
on it.
I think it is better to suspend the further proceeding, Lordship, otherwise
The order, if the order is suspended, how will it proceed? The order is a final, by this order,
then there will be confusion whether to proceed with the civil liability or not.
they can proceed with the civil liability. There is no bar in proceeding with civil liability.
In fact, I have challenged the entire proceeding also, Lord Prima.
No, at this stage, how can you challenge the
Further
proceeding?
proceeding of the land grabbing proceeding, if your Lordship says till the returnable date, Lordship.
No, we are challenging criminal parties. They can go ahead with having the cross-examination.
Lord.
We have
Obliged.
not testified anything up to them.
Lordship, obliged.
Total is 30. Certain matter.
Yes.
Here we have 31.
Generally came up on the part 2 list, my lord, but never reached. My lord, I am the landlord and I pray for,
Hopefully, it will be over
my lord,
after 10 years.
after 10 years, my lord. I am the landlord, my lord.
Petitioner is the plaintiff.
Petitioner is the plaintiff,
Landlord.
landlord,
One petition.
one petition, and one defendant. I prayed for eviction of the tenant, defendant, my lord,
Suit for rejectment.
suit for ejectment on the twin ground of default in
Defaulter
the
and bona fide ground.
bona fide requirement and default in the payment of rental.
fulfilled bona fide requirement.
The defense of the defendant, my lord, was that he is not a tenant.
In the
That
written
is-
statement,
That is the defense of the tenant.
okay.
Further, he claims that he is in the land on which I am laying my claim, Your Honor, my lord, that he is there as a lessee of the person from whose predecessor I have taken the land in lease. That is his second ground.
Not a tenant, he is a lessee.
Lessee, having taken the land from a person
Lessee,
from whose predecessor I have taken the land.
lessee of whom?
From the person,
Name.
he claims, my lord, Sachidanand Pandey.
Lessee of Sachidanand Bhatt.
Sachidanand Pandey.
Okay. And your case?
And my case is that he is my tenant.
No.
And I am the lessee of the predecessor of Sachidanand Pandey,
Who is the predecessor?
Ayodhya Pandey and Sarju Pandey.
They are the father of Sachidanand.
One is father and the other is uncle.
Petitioner is a lessee. You are also lessee.
Lessee.
Of predecessor of Sachidanand.
Of Ayodhya Pandey?
No, predecessor of Sachidanand.
Yes, my
Namely,
Ayodhya Pandey and Sarju Pandey.
Sarju.
Now, my claim starts from the year 1933, my. I am Sunil Kumar Chakravarti. My father was Nalini Mohan Chakravarti. And it was my father, Nalini Mohan Chakravarti, who came to possess the entire land, my lord, of which the suit property is a part, in the year 1933.
Yes.
My father expired in the year 1942, when I was only 9 years of age.
In 1930, your father, how he became the possessor?
He took the land
Lease.
on lease from the predecessor of Sachidanand Pandey.
Including the
90
suit, including the suit claim.
my land. And the suit property is only a part of the entire land of which I have become the lessee.
Yes, then.
Thereafter, my lord, 1942, my father expired when I was nearly 9 years of age.
Nalini passed away.
Nalini passed away, leaving behind me my mother.
Yes.
So it was my maternal uncle, Nirmal Chakravarti, who started looking after me and who also started looking after and managing the leased property.
Nirmal.
Nirmal.
Chakraborty.
Nirmal Chakravarti.
Yes.
He continued to look after, but in 1989, he handed over the entire property to me, to Sunil Kumar Chakravarti.
Yes.
My lord, this defendant, he is my tenant. He entered sometime in the year 1995.
Yes.
He continued to pay. He has got 2 rooms. One is being used as a residence.
Two?
2 rooms. One is being used as a residence, 1 room. And another
Room
room,
is to house.
not 2 house, my lord. There is a house in which one part I am residing, the other part I have rented out to others. So one small room, it's a very small area, my lord. One small room is being used as a residence by the defendant, and a room, another room, which is at a little distance, my lord, within the same campus, he is using as a stop.
2 rooms.
2 rooms. One, used as a residence, the other as a shop. Till the year 2001, my lord, he continuously paid the rental for the residence.
2001. Yes.
But thereafter he stopped.
Yeah.
And so far this shop room is concerned, my lord, he continuously paid up to 2005, my lord. 2006. February 2005.
Yes.
And he started laying claim over the two rooms, my lord, as its owner. And he even accumulated bricks and other constructional materials in order to improve upon it when the dispute arose. And this happened in the month of July 2005, which ultimately led to the filing of complaint under section 144 of CRPC before the district magistrate Dibrugarh.
You filed 144%.
File. And there the status quo order was passed by the district magistrate. Both the parties had appeared there.
Yes.
And my lord, during the pendency of the proceeding, we approached the civil court in order to get the eviction of the defendant.
Present suit.
Present suit, my lord. He appeared and he submitted his written statement and taking the two pleas that I have already spoken, my lord. The suit was decreed in the year 2006, December, my lord. The suit was filed in 2005. It is numbered as 89 of 2005, my lord.
Yes. So decreed.
Decreed in my favor on 22nd of December 2006. The judgment and decree was in my favor by the court of Munsif 1. While deciding the dispute, my lord, an issue which was not there was also taken up, adjudicated, which was wrongly interpreted by the Munsif court, and the defendant approached the first appellate court. The first appellate court reversed, saying this issue, the language of the issue, my lord, if I may point out, the issue was as to whether the suit property is bona fide required for the plaintiff. He took whether he is defaulter, saying the language is totally wrong. So ultimately the judgment was reversed and it was remanded back to the Munsif court to give a fresh judgment, allowing the parties to lead evidences so far actual issue number 5 is concerned.
What is the remand order?
The remand of the first appellate court is of is dated, my lord, 17th of December 2008.
Yes.
Thereafter, the press judgment was passed by the Munsif court, my lord, again in my favor. Again, it was decreed.
Then,
and it was again decreed on 30th of April, my lord, 2010.
Yes.
Thereafter, the defendant preferred the appeal, and this appeal was allowed. And the judgment was passed on 30th of March 2013.
Judgment by appellate court.
By the appellate court.
Allowed.
Allowed. There were 5 witnesses, my lord, including myself, on my behalf. And so far defendant is concerned, there was 1 witness, that is the defendant.
Yes.
I exhibited, my lord, in total 33 documents. So far the defendant is concerned, he exhibited 2 documents as exhibit A and B.
Yes.
The Munsif court took into consideration all the documents that we had exhibited, taken care of all the evidences that were laid on our behalf. So far the first appellate court is concerned, it only confined its attention to exhibit A, which was exhibited by defendant.
Yes.
My lord, before I further speak, let me show you certain relevant paragraphs of the plaint. And the plaint starts, my lord, at page 12.
Page 12.
Page 12, my lord.
Yes.
My lord, kindly take into consideration paragraph 5, page 13. The first three sentences, the minor plaintiff, his younger sister and widowed mother was looked after by the guardian, maternal uncle of the
Paragraph?
plaintiff. Paragraph 5, my lord. 4 and 5, my lord, can be read together. The father of the plaintiff, Nalini Mohan Chakrabarti, died in the year 1942 when the plaintiff was 9 years old. That the minor plaintiff, his younger sister and widowed mother was looked after by the guardian, maternal uncle of the plaintiff, Sri Nirmal Chakrabarti. The lease was converted in the name of said maternal uncle of the said plaintiff, Sri Nirmal Chakrabarti, being the guardian and sole major male member in the family. Though the lease rent and municipal taxes were paid out of the profit or income of the rented house on the leasehold and constructed by Nalini Mohan Chakrabarti, the father of the plaintiff, during his lifetime. The plaintiff and his mother, Priyabala Devi, now deceased, used to induct tenants time to time. During the course of the time, municipal holding number 2120 was renumbered as 81. Now I pause for a moment, my lord. This holding was in the name of my father. So on the leasehold property, my lord, my father constructed certain houses and shop rooms, and those were covered. Since it was within the municipal area, it was covered under municipal holding number 2120, which was subsequently renumbered as 81.
Yes.
And in support thereof, my lord, I exhibited at around 15, to be precise. I will show, my lord, how many exhibits. All the municipal receipts showing the continuous payments of municipal taxes against the holding. Now, within municipal area, my lord, there cannot be any house or residence without having any holding number. Now, my lord, kindly come to paragraph 6. What is the relevancy of this municipal holding? I will be speaking, my lord, a little later. Plaintiff rented out 2 residential rooms to Srimati Kanan Bala Sen. She is witness number PW 3, my lord, Kanan Bala Sen, wife of late Arun Sen and defendant on monthly rental basis. So Kanan Bala Sen and the defendant were having side-by-side rooms.
Yes.
The plaintiff also erected 2 roadside pakka swap rooms. 2 roadside, my lord. So this is inside 2 roadside pakka swap rooms. Eastern swap room was rented to one Sri Bachu Kumar Sharma and next western one to the defendant. Monthly rent for both the shops were fixed at rupees 300 per month. Bachu Kumar Sharma surrendered the shop to the plaintiff on 6th of April 2001, and since then the defendant shifted his shop to the eastern shop room by vacating the western. The plaintiff rented the above said western shop room to go down purpose to someone else, my lord. Now, paragraph 7, aforesaid maternal uncle of the plaintiff, by executing a document on 2889, handed over, assigned and bestowed the leasehold land and property in favor of the plaintiff. Now, my lord, kindly come to paragraph 9. Rent for the residential part was fixed at rupees 200 per month, and the defendant paid rent up to March 2001. The plaintiff renovated the residential.
Okay, we have to
My-
go to the government.
My lord, now kindly come to paragraph 12. Suit house is bona fide required for the purpose of the grown-up son Abhishek Chakrabarti. So 2 things are quite clear, my lord. I have spoken about the default in the payment of rental, my lord, in paragraph 9. That is why I was referring, my lord. In any case, now kindly come to
Default is in paragraph 9 and bona fide requirement.
at paragraph 12.
Yes.
Now, what is the reply, my lord? So far, my municipal holding is concerned, my lease is concerned. Kindly come to the written statement.
Now, what are the issues involved?
The issues, my
You
lord,
can straight away come to the issue. Where is the issue?
issue I have given at page number 4.
No, not the issue for the code. Issue here.
Okay,
Where
my
here?
Okay.
So under which
it is, my
ground
lord,
the appellate court has committed mistake.
it is issue number 3, my lord, whether the defendant is the tenant of the plaintiff in respect of the suit premises. That is the issue, my lord, which has overturned the judgment and has gone in favor of the
Let
defendant.
us see the findings of the trial court as well as the appellate.
My lord, let us first see the trial court's judgment, my lord. It is at page number 74. No, second.
Is number 7.
74, my lord.
Select the court.
My lord. Kindly come to the relevant page, my lord.
Yes.
It starts at the last line, first line of page 77.
Is it 13/4/2010?
Page 77, my lord.
No, date is 13/4/2010.
Yes, my lord. Yes.
By Munsif.
By Munsif.
Number 1. Dibrugarh.
My lord, yes. Dibrugarh.
Yes. That page.
Page 77, my lord. The son of Nalini Mohan Chakrabarti is the lessee of suit premises, and upon death of Nalini Mohan Chakrabarti, plaintiff's maternal uncle entered into an agreement with the lease agreement with the original Sarju Pandey and Ayodhya Pandey. The defendant by Exhibit A tried to show that Sachidanand Pandey gave him lease of
Where
the
are you
suit.
reading? 77.
Page 77, my lord.
Yes, which-
First line, my lord.
Yes. Who is the son?
Who is the son of Nalini Mohan Chakrabarti is the lessee of the suit premises, and upon death of Nalini Mohan Chakrabarti,
It continues from the time the earlier
that is not quite relevant, my lord.
one.
Yes, Exhibit 7 is the rent receipt that Sri Sunil Kumar Chakrabarti, that is the plaintiff, who is the son of Nalini Mohan Chakrabarti, is the lessee of the suit premises, and upon death of Nalini Mohan Chakrabarti, plaintiff's maternal uncle entered into an agreement with the lease agreement with the original owner Sarju Pandey and Ayodhya Pandey. The defendant by Exhibit A, this is Exhibit A, very important, my lord, tried to show that Sachidanand Pandey gave him lease of the suit property, but failed to substantiate through other convincing evidences. Since the suit is itself an eviction suit for which I find that it is not paid for non-gender of necessary party. Next para, my lord. PW1 deposed that he rented out one residential house and a shop room to the defendant, and the rent for the suit premises was fixed at so and so. In cross of PW1, there is a written agreement in respect of the suit premises. PW1 also deposed in chief that yearly lease was granted by Ayodhya Pandey and Sarju Pandey, and the rent was collected by Sarju Pandey, and after death by his heirs as Exhibit 7 is such rent receipts. PW1 also deposed in cross that for land tag number so and so, the original owner was Devcharan Pandey, as Devcharan Pandey got two sons, namely Sarju and Ayodhya. PW1 also deposed in cross that holding number 2120 was earlier allotted in favor of Nirmal Chakrabarti for the disputed house. Lease was his maternal uncle, Nirmal Chakrabarti. PW2 stated the defendant came into occupation of the suit premises as a tenant under the plaintiff and his brother-in-law, Nalini Mohan Chakrabarti, granted the above lease holding Ayodhya Pandey, and upon death of Nalini Mohan Chakrabarti, the father of the plaintiff, and he bestowed the leasehold of the property by document Exhibit 13 on the plaintiff. A perusal of Exhibit 13 reveals that said is the authority of the management of the landed property, which is the suit premises made by PW2 Nirmal Kumar Chakrabarti in favor of plaintiff on 2889. PW3 stated that C along with the defendant are tenant under the plaintiff, and C also deposed that subsequent to their tenancy, defendant's elder brother Madan Sen Burman came into occupation to the adjacent southern room as a tenant. This is very important, my lord. Madan Sen Burman. He is the elder brother of Ramakrishna, the defendant, my lord. So he was earlier the tenant. He left for Delhi for good, my lord. And when he left, he requested me to provide one room to his brother, which I provided the western room. Subsequently, he surrendered it and come to the eastern room. The defendant occupied the suit premises as a tenant under the plaintiff PW4, also deposed in cross that the disputed house is at the eastern side of Nirmal Chakrabarti house, and he also deposed in cross that the house not belonging to Nirmal Chakravarti as the same belongs to Ramakrishna PW4. Ramakrishna PW4 also deposed in cross that Nirmal Chakravarti is his tenant and rent for the house stayed by Sunil Kumar Chakravarti has been paid sometimes by Nirmal and sometimes by Sunil Chakravarti. PW5 deposed in cross that he doesn't know the fact that Sachidanand Pandey gave the disputed house to the defendant. PW5 deposed in chief that he know Madan Sen Burman, the elder brother of the defendant, who was a tenant under the plaintiff in respect of the residential room, and about 24 years ago, Madan Sen Burman left for Delhi, and since then the defendant residing in the room as a tenant under the plaintiff, who was subsequently taken on rent the roadside Pakka shop room from the plaintiff. DW1 deposed in cross that in the disputed house, Madan Sen Burman stayed since 1970. There is clear admission that earlier his brother was there in occupation of the shop room, now where he has been staying. And one Bachu Sharma's shop is situated adjacent to the disputed house. This Bachu Sharma name finds reference in my plaint also, my lord. DW1 also deposed cross that he cannot say if Madan Sen Burman has written anything by the exhibit 11 written in Bangla, my lord, which has been exhibited as exhibit 11, which letter was written by Madan Sen Burman while leaving for good to Delhi. And there, my lord, he has addressed me, Sunil Chakravarti, as Mangla, and he has also spoken about the defendant by his nickname. His nickname is Buran. So this exhibit 11 is also very important, my lord. But in cross, he stated that Kanan Sen occupied the room to his southern side under the plaintiff. DW1 exhibited exhibit A, which is an unregistered document only. A perusal of exhibit reveals that for the suit premises, Patta, Sunil Kumar Chakravarti, the plaintiff is in possession, and on perusal of exhibit 2, 3, 4, reveals that for the suit premises holding number 2120, Nirmal Kumar Chakravarti paid municipal taxes since 1974. A perusal of exhibit 16 to 30 reveals that electricity bills were paid since 1995 in the name of Nirmal Kumar Chakravarti, the maternal uncle of the plaintiff, for dag number so and so, which is corresponding to suit property. The evidences of PW's lend to the fact that the defendant is a tenant under the plaintiff, which the defendant failed to disprove. Though contrary, the defendant put up a plea that he is tenant under Sachidanand Pandey, but failed to prove the same.
Yes.
Now, my lord, in the entire description of the evidences, the Munsif has taken the pain of looking at different evidences, looking at different documents, and also considering exhibit A. Now, kindly see as to how the appellate court has dealt with and what are those exhibits, my lord.
Yes. Page
104, my lord. 104, and the relevant portion, my lord, is at 108. If I can start, my lord, from the last line of 107. My lord.
30th of March.
The date of the judgment, my lord, yes, 30th of March 2013.
Civil Judge Sugar.
Civil judge, yes. The relevant line starts, my lord, at the bottom of page 107 and continues at page 108. Sharma surrendered his shop in the year 2001. He is speaking about Bachu Sharma. The defendant appellant had shifted his shop to the said room. But the plaintiff PW1 in his cross-examination has admitted that there was correction made in the said exhibit. He has also stated that there is no agreement between him and the appellants. PW1 has further stated that there is no document in order to prove that he had taken the suit premises on lease with the Pandey family. PW2 Nirmal Chakravarti, who is the maternal uncle of the plaintiff, has also stated in his cross-examination that he has no document regarding his land, which is situated in Dibrugarh. PW3 Connection has stated in her cross-examination that the suit premises is situated in the eastern side of the house of Nirmal Chakrabarti, and she does not know the owner of the said suit premises. PW5 Sudhir Saha also stated that he doesn't know on which date the plaintiff used to collect from the appellant. PW4 Ramanand Pandey, who is the grandson of Devi Charan Pandey and son of Sarju Pandey, has deposed in his examination in chief that his father had given land to Nirmal Chakrabarti, where Nirmal Chakrabarti had built 3 rooms, of which 1 room is occupied by respondent plaintiff. And in his cross-examination, he stated that his brother Sachidanand Pandey had given land on lease to appellant defendant. I pause for a moment, my lord. Kindly see what he is saying. Nirmal Chakrabarti had built 3 rooms, out of which 1 room is occupied by respondent plaintiff. And in his cross-examination, he stated that his brother Sachidanand had given land on lease to appellant. So he is speaking about 2 things, my lord: construction of house as well by Nirmal, Sunil Chakrabarti or Nirmal Chakrabarti, whatever may be the case. And on the other side, leasing of land by his father to defendant. Exhibit A, he identified his brother's signature as Exhibit A1 to A4 in the said exhibit. He further stated that the suit premises is situated in the eastern side of the house of Nirmal Chakrabarti, and the said house belongs to defendant appellant, and it does not belong to Nirmal. He also stated that appellant is not his tenant, nor he is tenant to Nirmal. He denied that respondent plaintiff is tenant, but he stated that only Nirmal Chakrabarti is his tenant. From the evidence of PW4 Ramanand Pandey, it appears that respondent plaintiff was not his tenant, and he had identified only Nirmal Chakrabarti as his tenant. It also reveals from his evidence that appellant was given land on lease by his brother Sachidanand Pandey, to which PW4 had not objected.
What is meaning last paragraph? From the evidence of PW4,
It appears that respondent plaintiff was not his tenant, and he had identified only Nirmal Chakrabarti. Nirmal Chakrabarti, my maternal uncle.
Yes. Who's Ramanand?
Ramanand is PW4, my lord.
Who is it?
Who happens to be the son of Sarju Pandey. It also reveals from his evidence that appellant defendant was given land on lease by his brother Sachidanand Pandey, to which PW4 had not objected. PW4 has also categorically stated that the suit premises doesn't belong to Nirmal. This witness, being one of the legal heir of Sarju Pandey, proved that suit premises was given on lease to appellant, his brother, and that respondent was not lessee to him. Hence, from his evidence, along with the evidence of other witnesses, respondent, it is clear that respondent was not a lessee in respect of the suit premises. Rather, from the evidence of PW4, Ramanand Pandey, it shows the respondent stayed in one of the house made by Nirmal Chakrabarti, and PW4 Ramanand also stated that since 1970, the appellant defendant was permitted to stay in the suit premises by Sachita. Now, my lord,
Yes.
By proving Exhibit A. Now, my lord, the whole exercise so far the appellate court is concerned is in regard to the giving weightage to the evidence of PW4 Ramanand Pandey in some portion, and only identifying Exhibit A is the whole sole document. Now, before we look into that, my lord, may I again pray for your attention to plain. We are speaking about, my lord, 2 rooms. One is residence and the other is shop room. And we have given, my lord, the identification or the schedule of the property in our plaint. Kindly again come to plaint, my lord. Page 17.
Concept.
17. Shop room. Bottom portion, my lord. Schedule referred to above. One shop room being the eastern shop room measuring 6.5 feet by 13 feet, Pakka Assam type, and bounded as follows. Now, my lord, this is, I am speaking about one shop room which has been rented out to defendant. On the north, RKP Path. On the south, vacant land of the plaintiff. On the east, 5 feet passage of the plaintiff. On the west, Pakka Assam type shop room of the plaintiff. Now, my lord, next page, your lordship will find the residential room. One room measuring 13 feet by 22 feet. Comprising CI seat roof, wooden post, kacha floor, and bounded as follows. Now kindly consider, my lord, again the four boundaries. On the north, rented house of the plaintiff. On the south, vacant land and the latrine of the plaintiff. On the east, vacant land of the plaintiff. On the west, land of Ramanand Pandey. My lord, one thing is quite clear. So for shop, be it shop room or the residential room, nothing else has been rented out to the defendant. He doesn't have any kitchen there. He doesn't have any latrine there. Only two rooms were rented out to him. One was for the purpose of residence or for living for the time being, and the other for the shop room. Now, if you look at the sizes of the room, it is quite apparent that it was compact room, my lord, within my campus. Within my campus, I am speaking only inside my campus, and there are other lands belonging to Pandey family. I am not concentrating on those plot of land. Now, what happened, my lord, during the first trial before the Munsi, we raised this issue that he is saying that my room is totally different. Now, kindly see, he has also given one schedule, my lord, in the written statement, and he has also given one schedule of me. He is saying my correct schedule should be this, and his own room is under this schedule. Kindly take into account that, my lord. The written statement, my lord, page 33. Yes. So for schedule 1 is concerned, he has given tenanted house of Sunil Kumar Chakrabarti. As per the written version of the defendant, my lord. Schedule 1, as referred to above, tenanted
What is your
house
name?
of
What is your name?
Sunil Kumar Chakrabarti.
Your Sunil Kumar Chakrabarti.
Sunil Kumar Chakrabarti, my lord.
Schedule 1.
Schedule 1,
This is the WS schedule.
my lord. And where he has referred about this, my lord, kindly see page 31 of his written statement. Last 4 lines
Now,
of
why
it.
it is first?
I am
No,
coming
schedule
to
1 has been
He is
Can I-
saying, my lord, kindly take into account, he is saying a house premises consisting 4 rooms, roof with CI seat, wooden made doors standing on one plot of land covered under Dag number. Dag number is same, my lord. Patta number same. Situated at railway station, the other details are same. North railway station road, south vacant land of Sachidanand Pandey, east Ramakrishna Sen, west common tube well. This actually, my lord, this schedule actually is of the entire plot of land which is in my possession. The other details so far the rooms and residences and the shop rooms are concerned may be wrong, but this is the actual plot of land which is in my possession that he has spoken. And he has referred to about this in page, in last 4 lines of para 12, my lord. Para 12 of his written statement. So there is one admission, my lord, that I am also there. Kindly consider last 4 lines, my lord. There is clear-cut admission, page 31, para 12, last 4 lines.
Yes.
He has spoken that Nirmal Chakrabarti shifted to Makum and the plaintiff and his other family, last 4 line, my lord, also shifted in a rented house of Sarju Pandey at Railway Station Road, Dibrugarh, on monthly house rent payable to him on the first week of each succeeding English calendar month, described in schedule 1 herein below. So far my possession is concerned, be it as per his version as a
This is the
written statement, my lord.
let us read.
My lord.
Let us read again last time.
Last 4 line, plaintiff and his other family members shifted in a rented house of Sarju Pandey. He is not speaking about the year, my lord. at railway station, Dibrugarh, on monthly house rent payable to him on first week of each succeeding English calendar month. So other version is not acceptable, but one thing is loud and clear, that there is a clear admission that I am there as a possessor, my lord, of the land of Sarju Pandey. And he has given the entire area of land which is in my occupation in Schedule 1. The other details of the residences are wrong, but so far the land, the area of the land is concerned, that is there. Now come to his own area, my lord, page 34. He has spoken about, my lord, land measuring about 58 feet by 6 feet and 19 feet by 38 feet, totaling 1070 square feet. 7.6462 lessa covered by dag number so and so, patta number so and so, and thereafter he has spoken about the 4 boundaries. So where I am asking for his eviction from one residence room of a compact size, the other shop room of a very compact size within the area of land on which I am having my own residence and shop rooms, he is speaking about another area of land, my lord. So there was confusion. What happened at the time of argument, an application was moved for an inspection, local inspection. And the learned Munsif was pleased even to personally go along with the parties. Now kindly, I have flagged that memorandum of inspection, my lord. The application was moved on 7th of September 2006, my lord. Just today I have flagged 3 different colors flags are there, my lord.
7th of September
2006. An application was moved, which was numbered as 3137.
7th of September
2006.
That is a report.
That is the application was moved, my lord, and thereafter on 4th of November 2006, it was allowed to have a local inspection. Now, what was the reason for moving this application and what is the order? Kindly see the order sheet, my lord, file A, the LCR. The learned trial court realized that it's a compact area wherefrom I am asking for eviction. I am saying that one room is in my occupation, whereas the other room is in occupation of another tenant, and the third room is in occupation of the defendant.
Yes.
So the trial court on the 4th of November 2006 said that it is relevant to go and inspect as to what is the physical situation of the suit property, because he is not bothered about the property that has been spoken by the defendant. He is only concerned about the suit property. So he went there. And a report was prepared, my lord, which I have again flagged. The report is of third of December 2006, my lord. Fourth, okay, my lord. In the second line, my lord, it has been written as this memorandum of inspection is prepared on 3rd of December in the presence of both sides. There is a house to the north side of which there is a shop, and the other part. The memorandum of local inspection, my lord, I have flagged it, and it is in file A, my lord, if I am not wrong.
Yes.
This memorandum of my inspection is prepared on 3rd of December 2006 in the presence of both sides. There is a house to the north side of which there is a shop room, and other part to the next side remains vacant. The house situated to the south side is of roof top, perhaps, my lord. This house is in occupation by Sunil Chakrabarti, Kanakbala, and Ramakrishna. So one room is in my occupation, the other room is in the occupation of my tenant, Kanakbala, and the third room is in the occupation of Ramakrishna. Severely, each of the respective room by partition. There is a vacant space in front of the said house. the sketch map drawn below is the exact location and partition of the disputed each and, my lord, I cannot read this next word, and the house. This memorandum of inspection will form part of this record.
The sketch.
The disputed land and the house. This memorandum of inspection will form part of this record. Now, my lord, to understand the evidences, evidences, my lord, as well as the documents, my lord, this inspection was carried out in presence of both the parties. Now, one thing is clear, my lord, that the learned first appellate court even didn't delve into all these documents, and it was not considered. Now, if you consider, my lord, kindly see the map that has been given along with this memorandum of inspection. And if your lordship takes the pen of side by side opening page 17 of my plan, whether it is the same or not. Page 17. Now, if your lordship take the shop room.
Schedule in the pen.
Schedule in the pen, my lord. Kindly see the map, my lord, the sketch map prepared by the learned Munshi. So, my lord will find that on the north is the road, on the south is the shop room, which we are now seeking eviction of the defendant from. On the eastern side, there is a passage. And on the back side, my lord, the vacant space of the plaintiff. Now, kindly consider page 17 of my plan, the schedule. It is same, my lord, which I have spoken, not the one that has been spoken by the defendant. Now, I am seeking eviction from this schedule. And if my schedule, along with the memorandum of inspection, is looked into, then it is quite clear that both rooms are adjacent. Now, my lord, now comes my holding. I have spoken about two things in my plan. One is that the entire house and shops are under holding number 2120, which was renumbered as 89. The relevance of that holding now comes into play, my lord. So I am saying that this is the total area over which I have got the holding. And I am seeking eviction from one of the room which I had rented out to you. You are saying that I am not your lessee, I am not your tenant. Where is your document? Because you are claiming through Exhibit A. Now, kindly, three things I will urge your lordship to keep side by side. Memorandum of inspection, the schedule that I have spoken. Now, kindly see Exhibit A also. What is Exhibit A? And thereafter, the other relevant documents, my lord. So, schedule what I have spoken in page 17 and 18. So, for the residential room or the shop room is concerned, if your lordship also takes the residential room in the same map, my lord, kindly see where is Ramakrishna Sen at the extreme south, and the just adjacent room is to Kanakbala Sen, who is my tenant and who is PW3. And she has spoken that my side room has been rented out. Now he is saying in my campus, he is the lessee of Sachidanand Pandey through Exhibit A. My holding is there. He is not denying my holding. Nor he is claiming that after having taken the land from Sachidanand Pandey by virtue of Exhibit A, he has made any sort of construction and he has got his name covered under any municipal holding. Two things he has not spoken. Any person who is residing, my lord, is going to have the municipal holding, and on the strength of municipal holding, one can have the electricity connection. I have spoken about my municipal holding. I have spoken about the electricity connection, which is in my name. be it domestic, be it commercial. Now, kindly see, my lord, file C1, exhibit 1, that is the first document. Certain documents, my lord.
You can make a submission because see, we are on a revision of jurisdiction.
My lord,
It's
I
a
am
question
I
of
want to say
appreciating
that
the
total
evidence.
perverse finding is there, my lord. There was
No,
no
we have already showed the evidence. If we are on a revision jurisdiction, if we go to a fact finding against the entire.
My lord, but when there is perversity in the appreciation of evidence, because the entire attention was given only to exhibit A. Now, my lord, let us assume for argument's sake that he was a tenant, he was a lessee of Sachidanand Pandey. So what he was expected to construct and thereafter to get under municipal holding. Has he spoken that he is having any municipal holding in his name?
We have considered that there is no separate holding number which we have been talked about. There's only one.
And he is providing one schedule, my lord, which is non-existent. It is the schedule which I have spoken was found by the learned Musif on his visit in presence of. My lord, two more things may I say. Exhibit A, my lord, it states the right and liberty because it was executed only in the year 1995. Exhibit A. Neither it is registered nor it has been notarized.
Exhibit A by DW.
And your lordship will find that exhibit A says, though it was executed in the year 1995, it says that since 1970, I have given him on lease. And there is no reference of past deed. And he has been given the liberty to construct.
Exhibit A is executed by whom?
By DW1.
Name?
Ramakrishna Sen Burman.
In favor of the defendant.
In favor of the defendant.
Name of the defendant?
He is Ramakrishna Sen Burman.
Exhibit A
By
is-
Sachidanand Pandey.
That is,
By Sachidanand Pandey.
was Sachidanand Pandey in 1970.
No, it is in 1995, but there is a reference that it
he
was,
says that from 1970 it was.
that is the claim, my lord,
But it was executed in 1995.
1995. And there is no reference of any past deed. And one thing is clear, my lord, if your lordship takes the pain of looking at exhibit A, my lord, thereafter 2-3 more documents, my lord, which exposes the perversity and which also clarifies that the case was not adjudicated properly, my lord, by the
When did
learned-
Sachidanand pass away?
Sachidanand, my lord, I have no idea.
For the institution.
Sachidanand Pandey, my lord. His death has not been referred to anywhere.
But it's for the institution.
I will have to check, my lord. Sachidanand. Sachidanand is alive. Sachidanand is alive as per my brother is saying, my lord. So, Sachidanand is alive, my lord, because
Sachidanand is
Ramanand
alive.
Pandey, yes, my lord, but he has not entered the witness box. It is Ramanand Pandey.
Who's Raman?
Ramanand Pandey is the brother of Sachidanand Pandey.
But the executor took all lease, he was not
No.
there.
No, not there. Apart from that, my lord, if you look at exhibit A, your lordship will find that there is liberty to construct. So let us assume that he constructed because he is saying that I have already constructed. Kindly see the written statement, my lord. Two things, my lord. I shall be very brief now, my lord. My lord, kindly see page 32, para 21. Page 32, para 21. What is the claim in regard to exhibit A? Second para, para 21 sub para. In this context, it is stated that sometimes in the year 1970, the defendant and his father Ramesh Chandra Sen Burman and other family members came into occupation and possession of a plot of land more fully described in the schedule here in below on yearly rent at the rate of rupees 300 per year under Sachidanand Pandey, son of Sri Sarju Pandey, near Shiv Mandir railway station, Dibrugarh town, and constructed residential house thereon, more fully described in Schedule 2 herein below. Constructed, my lord. So if not with the execution of Exhibit A in the year 1995, if the construction was done way back in 1970, where is the holding, my lord? Where is the electricity connection in his name or in the name of any of his predecessor or in the name of the lesser? Neither any municipal holding nor any scrap of paper from other authority, my lord.
Did you put a cross-examination?
My lord, yes.
You had put.
Yes, yes, my lord. And apart from that, my lord,
Where is that?
it is in the cross-examination of
Yes.
DW1, my lord.
Yes, sir.
My lord, the handwriting is very illegible.
Doesn't it?
My lord, so there is, my lord,
Where is
that is, my lord, if your lordship opens DW1 cross-examination, Ramakrishna Sen Burman, my lord, is in file C1. Yes. I think that is the last evidence, my lord. From the last one and the last one from the side of defendant. মোর স্বাক্ষর শপথ পত্ৰত মোৰ বয়স 45 বছৰ ছেপ্টেম্বৰৰ পৰা নাই নিজৰ 4 ভাই আৰু 4 ভনী ভায়ে ক্ৰমে সুবোধ ৰাজবিহাৰী মদন আৰু মই আৰু অৰুণ অনু সন্ধ্যা my lord kindly take note of Madan.
Consider question regarding question on holding number.
Yes, my lord. Only holding, my lord.
That question that the written statement has claimed that he has constructed a.
My lord, this so far the electrical part is concerned. If your lordship comes to page 2nd, the last 5 lines, my lord, is about electricity, my lord. Electricity, মই থকা দোকান ঘৰত electricity wiring আছে লগতে electricity আহে ক'ব নোৱাৰো electric wiring কাৰ নামত বাদি সুনীল চক্ৰৱৰ্তীয়ে কৰি থৈছে দোকান ঘৰৰ পেজ 3 my lord first line দোকান ঘৰৰ যদি সুনীল চক্ৰৱৰ্তীয়ে থকা ঘৰ আৰু দোকান ঘৰৰ থকা ঘৰ বহা ঘৰ একেলগে বনোৱা and holding or so electricity so far is concerned, it is in my name. There is the last line of page 2, my lord, continuing at page 3. So how he can have electricity in my name in his own house? Page 2, my lord. Yes, my lord. It was page 2, my lord. It was the electricity connection, my lord. Electric wiring.
No, that's not.
দোকান আৰু ঘৰত ইলেক্ট্ৰিক ৱায়াৰিং আছে নে নাই মই ক'ব নোৱাৰো মানে হি তাৰ পিছত কি হ'ব উক্ত সকলো ইলেক্ট্রিক ওয়ারিং
সত্য নহয় সত্য নহয়
আচ্ছা যে উক্ত সকলো ইলেক্ট্রিক
সত্য নহয়
ওয়ারিং
যে উক্ত হতো ইয়াৰিং
বাদী সুনীল চক্ৰৱৰ্তীয়ে কৰি থৈছে দোকান ঘৰৰ যদি সুনীল চক্ৰৱৰ্তীয়ে very difficult my lord to my lord, if you look at page 2 itself, my lord,
Yes.
my lord, if cross examination from the first page in the middle portion your lordship comes, he has spoken about his brothers amongst whom he has spoken about Madan then Burman, and in the middle portion first page my lord cross examination প্ৰদৰ্শক 11 আখৰবোৰ মদনৰ হয়নে মই খাটাং ক'ব নোৱাৰো he is not denying মদন 19 চনৰ আগতে গৈছে মদন এজন 1981 চনৰ ছেপ্টেম্বৰ মাহৰ পৰা দিল্লীলৈ গৈছে মদন দিল্লীলৈ যোৱাৰ সময়ত দিবলগীয়া বাইক দিবলগীয়া হিচাপে ঘৰ ভাড়া মোক দিবলৈ টকা পইচা কৈ গৈছে So before leaving, his brother had been in possession of the swap room. He handed over the remaining balance amount to be paid through his brother, that is through defendant number 1. And that is why, since I was having so much good relation with Madan Sen, that I allowed him to enter the swap room without having any agreement. So he is not saying that Exhibit 11 has not been written by his brother. And in Exhibit 11, my lord, he has spoken Madan Sen about Mangla, who is me, my nickname. And he has also spoken about Buran. Buran is Ramakrishna Sen, the defendant, my lord. So he is addressing both me and his younger brother through nickname, which the defendant has admitted at second page, my lord, that his name is Buran also. And he also admits, my lord, at page 2 that he entered through Bachu Sharma in one room. Kindly see the 4th line, my lord. I hope my lord has been able to read. I have been finding very difficult, my lord. Vivadi Ghorar, and we tried to get it through translator, through copyist, but they also could not read. Bachu Sharmar Dukan Asil. Vivadi Ghorar. Asil. সত্য নহয় যে বাচু শৰ্মাই তেওঁ ঘৰটো এৰি থোৱাৰ সময়ত মই লওঁ নিৰ্মল চন্দ্ৰ চক্ৰৱৰ্তী আৰু মাটিৰ পৰা উচ্ছেদ কৰাৰ কাগজ মই দাখিল কৰিছো দিছো উক্ত সংক্ৰান্তে কোনো কাগজ দিয়া নাই my lord will appreciate that so far the entire premises is concerned, it is in my possession, out of which one room cannot be leased out, because he is saying I have been leased out land, the defendant, by Sachidanand Pandey. So Sachidanand Pandey cannot lease out one room. He is saying I have been given such large size of land. So he may be having a large size of land, he may be having a house there, but I am only speaking about my own suit property, and which was found, not as disclosed or as described by the defendant, as per my version, my lord, was physically found by the learned Munshi. Now these facts, whether this memorandum of inspection was considered vis-a-vis the exhibit A, no. So that is why I am saying, my lord, there was perversity. Whether exhibit 11 was considered, which was written in the handwriting of Madan Sen, no. Now whether the municipal taxes and receipts which I have produced, my lord, was taken into consideration, no. I have also produced, my lord, kindly see when I first took the electricity connection, kindly consider exhibit 16, my lord. 16, 17, 18, 22, all these relate to obtaining the domestic electricity and thereafter commercial electricity in my name. So this is the electricity which was enjoyed by defendant, though he is not admitting, but he is not denying also. When the question was put, electricity wiring to Karnamol, Moi Kobo Nuaro, when he is residing in a particular room, can he say that I do not know in whose name the electricity I am enjoying? So these facts were not considered, my lord, by the first appellate court. And that is why I am taking and giving the pain of this honorable court in revisional jurisdiction to look at the quality of appreciation done by the first appellate court in regard to the evidences produced, my lord. So if exhibit 16 onwards relating to electricity, if prior to that, my lord, the different documents relating to municipal taxes and municipal receipts are concerned, it is clear that the entire house shops are in my municipal holding, and there is no municipal holding in the name of the defendant. Whereas he is claiming since 1970, he is having his own construction, but failing to show a single scrap of paper. And apart from that, my lord, let us assume that the entire land he has spoken in Schedule 2 of his written statement is in his possession by virtue of Exhibit A. I am not laying any claim over there. If he is having the land, I am only confining to one room as a residence and the other room as a shop room. So if he is having the entire construction in his name, where is the documents to show that within the Dibrugarh municipal area, he is having any municipal holding? And in the absence of any municipal holding, nobody can have electricity connection. That is why he has kept mum, my lord, when the question was put as to whether you have the electricity and whether the electricity is in the name of Sunil Chakravarti, Moi Kobo Nuaro, can that be an answer from any person with ordinary prudence? So, my lord, and Exhibit 11, my lord, also may kindly be taken note of. And your lordship will find that in Exhibit 11, the letter written by Madan Sen Burman, he is not denying. He admits that his nickname is Buran. So why Buran will go to pay the remaining balance amount and thereafter will enter the shop room as a tenant, if he is having in his own name? And apart from that, my lord, I was talking initially about Exhibit A. There are three things. It speaks about the original lease being given in the year 1970 without reference of any previous lease deed and as to with whom it was entered into. Second, your lordship, at page 2, if your lordship only spends 10 seconds, my lord, it speaks that he is entitled to have electricity in his name. So if that power has been given, why no electricity in his name since 1970 or at least from 1995 if the document itself is genuine? And it also speaks, my lord, at column number F, the right and liberty to make construction. So if he has constructed as he is claiming, where is the holding? So these things, if taken into consideration, my lord, this becomes clear that there is perversity in appreciation of evidence.
May I please, your lordship?
And one judgment, my lord, about perversity by the Supreme Court, if your lordship permits.
Yes.
EIR 1999 SC, my lord, page 2507. Of course, my lord, this exercise is in a very limited manner. It is not as expansive and as exhaustive as an appellate court, but it says that High Court is obliged to place the order of the rent controller on the touchstone of whether it is according to law. For that limited purpose, it may enter into reappraisal of evidence, that is, for the purpose of ascertaining whether the conclusion arrived at by rent controller is wholly unreasonable or is
Paragraph?
one
Paragraph?
paragraph 11, my lord. Even the head note, my lord, can look into, that is very brief. No reasonable person acting with objectivity could have reached, and the conclusion on the material available, ignoring the weight of evidence, proceeding on wrong premise of law, or deriving conclusion for the established facts has betrayed the lack of reason. Now, my lord, in my case, on the whole sole attention has been given to Exhibit A, but paying no attention to other exhibits, because Exhibit A, whether it is reliable, acceptable, that has to be considered. And one or two stray sentences from Ramanand Pandey. Ramanand Pandey, my lord, may I clarify? He has said that it bears the signature of my brother, but whether he also says that it is the correct one. Admitting signature of Sachidanand Pandey on Exhibit A, whether will make the document admissible in evidence in the absence of any other supporting documents, more particularly in the absence of any municipal holding or electricity connection for 35-40 years, my lord.
Yes.
Obliged.
May I please your lordship? Lordship, so for concern to the Nalini Mohan Chakraborty lordship, who is not
What is your name?
Arbor. I am sole respondent, dependent in this case, lordship. Yes, lordship. So for concern to Nalini Mohan Chakraborty lordship, Nalini Mohan
His
Chakraborty
father.
is father. Nalini Mohan Chakraborty is not original occupier of the land, which is made in the plain, wrongly stated in the plain that he is the original occupier of the said 17 lecha of the land and the said this suit premises, owner of the suit premise. Actually, house of the original occupier of this land, lordship, we have stated in the our written statement, which is your lordship, please to find page number 29, lordship. Devicharan Pandey, lordship. In their witnesses also deposed before the learned trial court as well as learned appellate court also, that Sachidananda is the original occupier of the land. That Sachit Devicharan Pandey, Raghunandan Pandey died, son of Suraj Pandey and son of Ajudha Pandey, who is died, and son of Ramananda Pandey and Sachidananda Pandey. Their name is being before this honorable court is frequently this Sachidananda Pandey lordship. And the lease agreement, the Sachidananda Pandey given the lease to the not this petitioner lordship, not plaintiff petitioner lordship. This lease given to the Nirmal Chakraborty, who is grand maternal uncle of the petitioner, which is also stated we have clearly in the Nirmal Chakraborty lordship. So my respectful submission in this,
You said that the original occupier was Devicharan.
Devicharan, father of the Sachidananda and Ramananda Pandey.
No, not father. Grandfather.
Grandfather, sorry, lordship, grandfather of the and father of the Suraj. Their father is Suraj Pandey. Soju Pandey.
And you said that Sachidanand reached out to Nirmal.
Yes, Nirmal Chakraborty, who is maternal uncle of the petitioner plaintiff. This petitioner plaintiff no longer is the leasee in this case, lordship.
he has no locus stele to file this recovery of the area or recovery of the rent or ejection, want to ejection of the defendant, Lordship. Now, Lordship, I would like to draw the another attention regarding our written statement.
But he had exhibited some document that it was handed over to the petition.
Yes, I am coming to that point.
That Nirmal, his maternal uncle, had
Nirmal is maternal uncle. They have given the deposition also before the court. I am coming to on that also, Lordship. See, in the written statement, we have clearly stated our pleadings, Lordship. That is page number 32. Your Lordship, please find page number 32. Yes, page number 32, paragraph number 21, Lordship. May I read, Lordship? Find it, Lordship. Yes, yes. In this contest, it is stated that sometime in the year of 1970, the defendant and his father, Ramesh Chandra Sen Bormon, and other family member came into occupation and possession of the plot of land more specifically described in the schedule here below on yearly rent at the rupees of 300 per year under the Sachitananda Pandey and son of the Suraj Pandey near Shiv Mandir and so on in this area, and this is the schedule. And defendant and other family have been residing on the said land, and as such the plaintiff having no right to make any comment of the enjoyment of the land defendant under the reference of the plaintiff having no right to locus there to make any comment. So, Lordship, we have made our pleadings that we are tenant of the Sachitananda, not this plaintiff petitioner. He is not our landlord, Lordship. He is no leasee. That court also find out the thereafter, Lordship. I would like to come directly to the judgment of the learned trial court, Lordship. Then in learned trial court, there are two judgments and order, Lordship. First judgments, I would like to draw the attention of the first judgment, Lordship. That is starts from the page 48, Lordship.
Yes.
Yes. In this case, Lordship, issue has been framed. I am directly coming to the issues, Lordship. Issue has been framed, Lordship, where the cause of action of this case, whether the suit for non-joinder of the necessary parties are there. In this case, Lordship, all these issues decided in the favorable to the petitioner plaintiff, Lordship. That is why I am saying that this is perversity of the findings, Lordship, because, Lordship, non-joinder of the necessary parties. Here is the original occupier of the land is Sachitananda's family, Lordship. His grandfather's Sachitananda's family, Lordship. But they have not been made parties in this case, Lordship. So this is my respectful submission before this honorable court. This is non-joinder of these parties. Thereafter, Lordship, whether the defendant is tenant in respect of the permission, whether defendant attended the suit premises, whether the defendant is defaulted to pay any rent for the suit premises, whether the plaintiff is entitled to decree as paid for, whether any other relief or release. These 7 issues have been framed by the learned trial court, Lordship. And thereafter, against this judgment and decree, against this order, the defendant moved before the civil judge, Dibrugarh, Lordship, against challenging the validity and legality of that judgment. And thereafter, in the judgment, in the impugn these judgments, Lordship, it is found that the bona fide requirement has been discussed in the issue number 2, issue number 3, but without considering, without having the bona fide framing the issues they have discussed, which look after by the examined by the appellate court and remand back this. Yes, page number, Lordship. Second judgment, your Lordship will find 74. Lordship.
No. That bona fide was not.
Yes.
Was not.
Yes, Lordship.
Appellate court.
Yes. Yes, Lordship. The appeal is directed against this appeal start from the page 92, Lordship. 92. Yes, Lordship. And appellate court also framed the issues, Lordship. The following 7 issues has been framed by the appellate court, and thereafter, Lordship, it is findings of the learned court, your Lordship, ultimate finding of the court, your Lordship, please to find in page number 96, Lordship. Page number 96, second paragraph. Lordship. Yes, may I read? Non-discussion of one of the framed issued in the judgment and discussion of the issues which were beyond the list of the issue and pleading of the parties do not reflect the cases of the contending parties, and as such the entire suit suffers from the serious prejudice. Under this, the discussions made above, I am primarily of the view that the suit need to be remanded learned trial court for discussion of issue number 5, whether the suit premises is bona fide required to the plaintiff. As the result, the case has been remanded. Thereafter, Lordship, learned trial court again taken up the hearing, the press Lordship, and this judgment, your Lordship, will find page number 74. Lordship. Starts from 74, Lordship.
Yes.
Yes. In this this appraise hearing also the learned court, trial court below from charges from issues, Lordship. This issues as whether whether there is a cause of action in the suit, whether the suit is made for non-joinder of the necessary party, whether a defendant is the tenant of the plaintiff in respect of the suit properties, whether defendant altered the suit premises, and whether the suit premises is bona fide required to the plaintiff, whether the plaintiff is entitled to decree as paid for, whether any relief or relief the parties are entitled to. And in this case, Lordship, learned trial court, while discussing the issue number 5, yes, Lordship, that is your Lordship will find page 79. Page 79, regarding the issue, plaintiff failed to substantiate any evidence, hence this goes against the plaintiff. Lordship, bona fide requirement of this suit premises is done, Lordship, because learned court will already decided. There is another Lordship issues that whether there is any altercation, my our senior advocates already submitted that there is constructions, latrines on any other, etc. But learned trial court's finding was that whether the defendant altered any suit premises in this issue, Lordship, yes, Lordship, the plaintiff failed to substantiate through the evidence that defendant has altered the suit property. Altered the suit property, hence issues goes to the
You can
negative.
concentrate your arguments or submission on the points which are relevant to us.
Yes,
Bona
Lordship.
fide is against him. Appellate court has he is not agreed by.
Yes. Thereafter,
You concentrate on the portion on which Mr. Singh has advanced his argument.
yes, yes,
That while criticizing the appellate court decision,
yes, Lordship. I am coming to the now appellate court decision.
he has made 2 points. Not 2 points. this point that even admitting that exhibit A is accepted, it is a lease deed for certain land where you claim that you have constructed, make some constructions and staying there. So the construction will have a holding number
Yeah.
and some corresponding electricity connection. In whose name the holding number?
Yes,
is there?
all the holdings numbers in the electric connection or municipality holdings are in the name of the lordship, this Nirmal Chakraborty lordship. That I am coming to
So that means are you admitting one sense that you are the tenant of Nirmal Chakraborty?
no, I am not Nirmal Chakraborty tenant. I am tenant of the Sachidananda Chakraborty.
Then why the holding is in the name of Nirmal Chakraborty?
Yes, not our premises, so the 17 lessors occupied this land.
We are connected, we are asking a question that the room,
Yes.
which is the part, is the subsegment of the suit,
Yes.
which you are occupying, has electricity connection, it's a construction. Construction needs to have a holding number.
Yes,
Do you have a separate holding number?
separate holding number.
You have.
In the name of, no, lordship. we
You don't have a separate holding number. The holding number is of the entire house.
entire house,
premise.
yes, yes.
It is in the name of Nirmal.
No,
So if
not this plaintiff petitioner.
no, that means are you accepting that you are tenant of Nirmal?
Yes,
You are
Nirmal
accepting.
Chakraborty.
You are tenant of Nirmal.
No, lordship. I am not the tenant of the Nirmal Chakraborty. I am tenant of the Sachidananda Pandey.
Then why Sachidanand's name is not there in the holding number?
Yes, lordship. This Sachidananda Pandey.
The electricity is in whose
Yes,
name?
Sachidananda Pandey give the list to the Nirmal Chakraborty lordship. That is why I am in my name is not holding number. So today I am paying my whole rent to the Sachidananda. Even today also I am paying yearly rent.
Of a premise whose holding is the name of Nirmal.
Nirmal.
You are paying to somebody else.
Yes.
How could Nirmal have the holding number if the land belongs to the city?
Yes, Sachidananda Pandey leased the land to the house and power to this Nirmal Chakraborty
He
lordship,
has
who is
also-
the maternal uncle of the plaintiff
Now,
petitioner.
It should have been in your name. If it would have been in the name of one leaseholder, you are also present leaseholder. Why is it not in your name? Why there was no application for change of the holding number?
Yes, in the appellate court lordship, that question has been answered clearly, lordship. I would like to come, lordship.
What do you say about the memo of local inspection? It was a fact-finding query. The
Local is actually I have no
local
instruction
inspection
about
report-
the local.
local inspection report and the schedule in the plaint are there is absolutely similar.
Lordship, local inspection, this report, this instruction I have not given my client.
No, it is a part of the report. It's a part of the record.
Yes, yes.
It started trial court here in the revisional jurisdiction. It has gone to the appellate court,
Yes.
then to the trial this court. There is the local inspection.
Yes. So my case is lordship that I am not the leasee of this plaintiff petitioner lord, and trial court passed this decree or judgment in the favor of the plaintiff, which is in perverse in nature. Lordship. Thereafter, we have approached before the appellate court, and appellate court reversing the judgment, finding that there is no question of that he is leasee, lordship. I would like to draw the attention in the page number, lordship.
Page?
Page number 108, lordship.
Consideration.
Yes, lordship. The page, yes, senior advocate already relying this paragraph. I also relying on this paragraph. This last portion starts from the 107, lordship. Sharma surrenders his shop in the year of 2001. The defendant plaintiff had shifted the shop to the said room, but the plaintiff PW1 in his process has admitted that there is a correction made in the said exhibit. He has also stated that there is no agreement between him and plaintiff. PW has further stated that there is no document in order to prove that he had taken to the suit premises on lease from the Pandey family. He has not taken to PW2, Lordship. This is very PW2 Nirmal Chakraborty, who is the maternal uncle of the plaintiff, has also stated in his cross-examination that he has no document regarding his land which is situated in the Dibrugarh. And Lordship, thereafter, their witnesses, Lordship, these are PW3. Kanak Sen has stated in her cross-examination that the suit premises is situated in the eastern side of the house of Nirmal Chakraborty, and she does not know who the owner of the suit premises. PW3, PW, I think it will be 4. PW for Sudhir Shah also stated that he does not know on who is the plaintiff used to collect from the appellant defendant. And Lordship, this is their witnesses PW4, Ramananda Pandey, who is the grandson of the Devicharan Pandey and also Suroj Pandey, and son of Suroj Pandey have deposed them in examination in chief that his father had given the land to Nirmal Chakraborty, where the Nirmal Chakraborty had built 3 rooms, out of which, that is why the whole holdings numbers in his name, Lordship, which 1 room is occupied by the respondent plaintiff. And in his cross-examination, he stated that his brother Sachitananda Pandey, PW4 is their witnesses, Lordship, not our witnesses. He stated that his brother Sachitananda Pandey had given land on lease to the appellant defendant Bhait Exhibit A, and he identified his brother's signature so and so and so, and he further stated that the suit premises is situated in the eastern part of the house of Nirmal Chakraborty, and the said house belong to the defendant appellant, and it does not belong to the Nirmal. He also stated that the appellant is not his tenant, nor he is not tenant to the Nirmal, which I am submitting before this honor. He denied that the respondent plaintiff is his tenant, but stated that only Nirmal Chakraborty is his tenant. From the evidence of PW4 Ramananda Pandey, it appears that respondent plaintiff was not his tenant, and he had identified only Nirmal Chakraborty as his tenant. It is also revealed from the evidence that appellant defendant was given land on lease by brother Sachitananda Pandey, to which PW4 had no objected. PW4 have also categorically stated that the suit premises does not belong to Nirmal. The witnesses, being one of legal heirs of Suraj Pandey, proved that the suit premises was given on lease to the appellant, his brother, and that the respondent was not leased to him. Hence, from his evidence along with the evidence of the other witnesses respondent, it's clear that the respondent was not leased in respect of the suit premises. Rather, from the evidence of PW4 Ramananda Pandey, it shows that the respondent stay in one of the house made by the Nirmal Chakraborty, and PW4 Ramananda Pandey also stated that since 1970 the appellant defendant was permitted to stay in the suit premises by Sachitananda, and by proving exhibit A has been able to prove by the plaintiff was leased to the Sachitananda Pandey. This is the ultimate findings of the learned appellate court, Lordship. And thereafter,
Let us see PW4.
yes, Lordship.
Is there the origin code? We have to take it up from other.
Yes, Lordship.
PW4 to 2011.
Yes, PW. Monday. Lordship, it can be taken a part. to the partner.
We pretty good. Every time for me, partner, but this is the second time. Next week, there's a change.
If Lordship is,
Both of you
Lordship is
come from
pleased to take
Tezpur
up.
or what? Both of
Your
you, come-
lordship direct, I will stay back on Monday. It can be fixed. We have holiday.
you are
there.
also from Tezpur.
Lordship. But Monday I have some difficulties with Monday and Tuesday. Lordship.
What about Thursday next?
Thursday, yes, Lord. আপনি সব দাদা Thursday.
We gave preference because both of you are outstation lawyers. Otherwise, we had a judgment to dictate.
28.
We gave precedence to your case. We thought it would take up maximum half an hour.
I'm sorry for consuming a lot of time, my lord.
Doesn't matter. Yeah, that Thursday is it okay?
My lord.
Yes.
Hard. Yes. Senior counsel. But assisted by Shruti, Senate counsel for the petition, whereas R. Purva, Senate counsel present. Due of the hearing not complete. Not complete. This, as agreed with, but this on Thursday.
20.
21, 28. 28.
Give it. Delivery of order. There's a matter where delivery of order.
Lordship can be taken away the top
We
of
have
the list.
indicated due to power for the hearing, but let us
So if top of the list, then
on Thursday as part.
develop.
Delivered. We have more or less come to a consensus on the admissible thing. You will hold this monthly income to be a reasonable one. Because the employment was of wrong back and the I-card is not a, and the medical expenses of 5320 will be included. And the spousal consortium, parental consortium, and the increase of 10% as per pronouncement is after every 3 years.
Yes.
Plus 7% will hold to be reasonable. You can do one thing. We'll pass the judgment. You make the calculation, agree upon it, and give it to the court. The judgment will be of this. Income will not touch on this. Because I-card accident, I-card is of 2009. And the accident was of 2014. After 5 years, it's not put in. We'll hold this at the learned court has held at 5,000.
Yes. Rate of interest.
Rate of interest. 10% will consider, but give the calculation on the agreed part. On the consortium, then holding the income as 5,000, that is we are not touching. We have already indicated husband spousal consortium, parental consortium 40,000 and enhancement of 10%, 10,5,320 medical. That's it. But Monday morning, you will incorporate and make it available. Rest, page 50.
My lord, I have item number 54, my lord.
Yes.
So file a petition impleading and abatement, my lord, of appeal on 3/4/2023. Now it is listed before your lordship. So today is a paucity of time. So date may-
We'll have a date, early date.
yes,
Okay. Yes. Mola, come early date. What was your matter you had mentioned?
44.
And what was it?
Matter, my lord, your lordship has granted injunction. There are
A violation.
a violation. Only one defendant has started construction. If he is not restrained, my lord, the other defendants also will get an encouragement.
Today will not be possible. Early date. Wednesday.
My lord, 53 also same matter is there. I pray for listing on
Extension.
27.
Is it pay or what?
No, I'm for the other side, lordship.
Date will be.
My lord,
On 27th,
Yes, date.
my lord, our interim order may continue. Interim order may continue. 44, item 44.
Paucity of time not allowed to make example. So interim order passed. Then they can- This is as wait. This is on Wednesday next the date. Order passed.
Master.
Lordship, item 21, can it be fixed on October?
He'll give the date. Madam, anything?
Item 32 and 46, they come up on 29.
Date he'll give, don't worry. Any matter where interim order is extended. Madam Chakraborty, anything?